Thank you, the Honorable Basarga, our Vice Chair. Now to proceed,
Affirmative Delivery Services
salamat.
to the Committee on Labor and Employment. House Bill 3785, renewing for another 25 years of untitled.
Good afternoon to my co-chairman, Honorable Marvin Marino, of our Committee on Trade and Industry, to our colleagues, the members of the House of Representatives, invited resource persons, guests, and to the public watching via the FB page of the House of Representatives. Thank you for your attendance and cooperation that in spite of the inclement weather, we are here to perform our task and to help clarify issues surrounding the transaction between TV5 and ABS-CBN. In today's meeting, the Committees on Legislative Franchises and Trade Industry will conduct a joint hearing on the privileged speech of the Honorable Representative Rodante Marcoleta, delivered in the plenary on August 15, 2022, and referred jointly to these committees on August 16. Representative Marcoleta will discuss the details of his privileged speech later on. Let me emphasize that the mandate of the Committee on the Legislative Franchises is the granting, amendment, extension, or revocation of legislative franchises. It is also authorized to exercise its oversight function to determine whether or not the laws passed upon within its jurisdictions are being implemented and carried out in accordance with the intent of Congress. We commit to a fair hearing to all parties concerned. For the initial deliberation of the subject privilege speech, we have invited resource persons from the different government agencies that will assist the committee in considering the issues submitted to its jurisdiction. May I now recognize my co-chairman, Harvey, for his preliminary remarks. Chairman Harvey.
Thank you, Mr. Chairman, Gus Tambunting. For expediency purposes, I will just do away with my opening remarks and make comments later. So go ahead, Mr. Chairman.
Thank you, Chairman Marvin. May I now ask the COMSEC to inform the committee of the first persons who responded to our invitation.
Thank you, Mr. Chairman. In today's meeting, we have the following resource person. From the National Telecommunications Commission, we have Attorney Gamaliel Cordoba, Commissioner, and Engineer Edgardo Cabarrios, Consultant. We also have from the Philippine Competition Commission, Commissioner Johans Benjamin Bernabe and Mr. Ramon Jeriel Sawi. From the Securities and Exchange Commission, we have the General Counsel Romuald Padillo, Director Vicente Graciano Felizmeño Jr. for the Markets and Securities Regulation Department, Assistant Director Emma Valencia for the Markets and Securities Regulation Department, and Attorney Ann Kathleen Gatdula from the Office of the General Counsel. Your Honors.
Thank you very much, COMSEC. Also, since we're about to enter the deliberation proper, may I ask also the COMSEC, let us to discuss some of the ground rules that we prepared for an orderly meeting. May you please discuss the ground rules that we have set for all members to understand and follow. Thank you.
With the permission of the Chairman, we have the following ground rules. Number one, the members will be allowed to interpolate our resource persons for 20 minutes per member. and the time allotment will include the questions and answer. Thus, resource persons are reminded to answer direct to the question only. Number 2, the members will be recognized on a first to register manner. And please register with the committee secretary by leaving a message in the chat box of this Zoom or by text message or Viber message. We also request the members to refrain from asking questions already answered, except when seeking clarifications. In the event that the member who has the floor has not completed his questioning after the 20-minute period, he may avail of the second round when time permits. Otherwise, he will be listed for the ensuing hearings. Number 5, the members will not be allowed to interrupt an interpellation of another member. And number 6, please observe proper decorum and avoid heated arguments. Always address the chairman in asking the questions and giving the answers, and wait to be recognized. Thank you, Mr. Chairman.
Thank you very much, Comsec. So I will request that the ground rules be observed for a very productive and efficient meeting. So now, to start with, we have invited resource persons from different agencies, and we will to address the committee. We will now ask each one. You have copies of the privilege speech of the Honorable Marcoleta. May I know if you have a presentation, a statement, or position paper to submit for the committee? Maybe start with, can you call NTC? Let's have NTC first.
Good morning, good afternoon to all the members of the two committees present this afternoon.
I know who's speaking.
Narinig niyo po ako,
Yes.
malinaw.
Sino po sila?
Okay. Ano po, magandang hapon po. This is Commissioner Cordoba po ng National Telecommunications Commission. Good afternoon to everyone, and we thank the chairpersons of the two committees for giving us the chance to attend this hearing this afternoon and to give our insights and ideas on this item. Mr. Chair, paano po ang do I proceed? Paano po ang gusto nyong?
What do you have to say? You read you have a copy of the privilege speech.
Yes.
Anything that you'd like to submit or say before this committee?
Okay. Yes. Thank you. Thank you for that. Thank you for the clarification, Mr. Chair. Okay. I would like to inform the honorable committees, that the honorable members of the committee, that the National Telecommunications Commission issued a memorandum order dated 23 June 2022, memorandum order number 36/2022 po yan, ano. Basically po, the memorandum order states that if a franchise holder would enter into a contract, a commercial contract with another entity, that said entity should have no obligations sa sa outstanding obligations sa national and local governments. So for purposes of this, bago po namin aprubahan ng isang commercial agreement entered into na may jurisdiction po ang National Telecommunications Commission, ay hihingi po muna kami ng clearances dun po sa kakontrata ng franchise holder, and that includes clearances from the Department of Finance. Nandyan po kasi ang Bureau of Internal Revenue, nandyan din po ang Bureau of Customs. And magbibigay din po kami ng clearance kung wala pong pending sa amin na babayarin or admin case. And hihingi rin po kami ng clearance from the Securities and Exchange Commission. And binanggit ko rin po kanina na kailangan din po ng clearance from the local government units. Kunwari po ba, meron po bang utang itong entity na to or corporation na to sa local government in the form of local taxes or real property taxes? Bayad po ba siya sa kanyang amilyar? Yan po ang aming mga hihingin po na mga clearances. Ang dahilan po niyan is, alam niyo po naman, we would want to enforce collection dahil kailangan po ng ating gobyerno ng collection, lalong-lalo na po because of the pandemic. So, meron po tayo mga emergency expenses na kailangan po ng tulong ng ating pamahalaan. That's why we came up with this memorandum order. So, kung ito po ay itutuloy ng TV5, ang kanila pong transaction with the ABS-CBN, then we would ask for the said clearances to be submitted to the NTC before we can approve po the commercial agreement that they entered into. Yun po ang bali ang basis po namin would be the memorandum order that we issued last June 23, 2022, Your Honors.
Okay, so yun lang ang ano mo.
Salamat po.
Meron ko bang
Yes. Ano po yun, Mr. Chair? Mr. Chair, can you repeat po? Sorry po, hindi ko po nakuha.
Will you be submitting any ito memorandum order sa mga
Yes. Yeah. Yes, yes.
Committee dito?
Yes, Mr. Chairman. Opo, Opo, we will submit po our copy of the memorandum order to the honorable committees for your consideration po. Salamat po.
Salamat. Now, are you done? Commissioner Cordova?
Ano lang po, maybe an additional item po, ano. There is a pending case po sa NTC against ABS-CBN dahil po may violations ang ABS-CBN sa amin noon pong 2020 kung saan po ay pay-per-view without authority from the commission. So yun po ang isang violation na kailangan po muna namin matapos bago po kami makapagbigay ng clearance. Yan po ay isang kaso na pending po sa amin. Yun po, Your Honors. If the Honorable Committee wants, we can also submit a copy of that pending case before our office.
Mr. Chair.
Okay.
Mr. Chair.
Yes, Honorable Marcoreta.
Mr. Chair, may I ask the Honorable Chairman of the NTC if the other violations established during the hearing of the renewal of franchise of ABS-CBN are not considered violations because he only mentioned the violations in connection with the pay-per-view committed by ABS-CBN for the lack of authority of what we call the conditional access system. Did he not consider also the violations like the lack of permit of the encryptment of the content and the encryption of the signal is also a violation, and it lasted for several years, not only weeks and days, Mr. Chair. It has no permit for the digital broadcast of its 11 channels, Mr. Chair. Also, ABS-CBN violated the cease and desist order. It also sold millions of black boxes throughout the land because without which the encrypted content cannot be viewed by our people. That is the reason why they violated their free-to-air contracts. These violations, Mr. Chair, that's why I'm asking the Honorable Chairman, because he should have included them in all in the context of violations as per the provision of the Public Service Act, which is 200 pesos per day per violation, Mr. Chair. As a matter of fact, I remember telling the NTC chairman if he has already computed all the violations established during the hearing. And I was told initially that the amount of the violation, Mr. Chair, is insignificant. Of course, I beg to disagree with him because I made a computation, a detailed computation of all these detailed violations. And I came up with trillion peso violation, Mr. Chair. So if he's talking only of the pay-per-view violations, I don't think that is complete. May I ask the comment of the NTC Commissioner, Mr. Chair?
Mr. Chairman, can I respond po? Yes, Mr. Chairman, yung po mga binanggit na violations po ni Congressman Marcoleta, we will look into it per detail po yun, ano? Kasi po, we cannot say that it's a violation right now or hindi. Depende po yan dun sa magiging labas po ng aming investigation. Kasi po, kakaroon po yan ng notice and hearing po sa concerned na corporation.
Mr. Cordoba, sinabi ko naman sa iyo noon na umpisahan mo ng usisain at imbestigahan. Matagal na yun eh. 2020 pa yun. 2 taon ang nakakaraan. Bakit naman hindi mo kasi sinimulan?
Actually,
ang pagkakaalam ko dyan, alam nyo rin na walang, you will admit that there is no permit dun sa encryption ng signal. Wala ring permit dun sa encryption ng mga contents. Hindi ba tama yun, Mr. NTC? Commissioner?
Opo, yun pong case na final sa amin ay tungkol po doon, sir. Yun po yung encryption po.
But motu proprio, you can investigate already because that is the reason why the franchise was not reviewed in the first place. Wala siyang permit for digital broadcast. At ito hindi lang days, hindi weeks, hindi months. It lasted for several years, Mr. Chair. At nakita mo rin yung when they migrated from analog to digital contents. Hindi ba nagkaroon sila ng demonstration, Mr. Commissioner? At you only allowed them for 3 months. But the demonstration continued for years. And these are also violations. So, I'm not still mentioning the violations about the PDRs, which is supposed to be the jurisdiction of the Securities and Exchange Commission, as well as the tax evasion schemes that they have employed, Mr. Chairs. Dahil nangako pa ang BIR dito. These are all obligations that the NTC should have investigated in the first place. Kahit naman siguro walang magdemanda o magasunto sa inyong opisina, Mr. Chairman, motu proprio kasi kasama kayo nung inimbestigahan natin yan. At ito'y public knowledge. At ang katotohanan nito, yung binabanggit po ninyong memorandum, Mr. Chair, hindi lang national, meron din po silang local obligations. Sa Quezon City lamang po, you will be surprised, Mr. Chair, na yung pong assessment ng kanilang building at saka kanilang machineries and equipment, broadcast equipment. Alam po ba ninyo yung assessment period nila? And 40 years pa po ang basis ng assessment nila eh. 1973 pa po yung iba, ang pinaka-latest 2004. Meaning to say, hindi po na-assess yung mga yung building nila at saka yung improvement sa loob, mga equipment, lahat ng ginagamit nila. In other words, yung basis po ng assessment mali na po eh, because bumibili naman po sila ng makabagong equipment eh. Because of the technology na mabilis pong lumaki ngayon, hindi po napupuntahan ng assessment ng assessor office yung mismong opisina ng ABS-CBN. Kahit na po yung building official, kailangan po siguro patawag natin sila. Hindi sila pinapapasok doon sa mismong planta o istasyon ng ABS-CBN. Kaya hindi po ma-assess yung equipment, yung mga makinarya nila dyan na binibili nila every year. Ang assessment po ay 1973 pa po. Paano natin makukuha ang tamang buwis kapag hindi nila pinapapasok ang assessor sa kanilang opisina? Pati po yung pinakamatas na transmitter. Kailangan po malaman nito, Mr. NTC Commissioner. Yung pong transmitter ng ABS-CBN, wala pong building permit yun. Paano po nangyari yan? Ito po lahat ay obligation eh. Kaya nga po ang sinasabi natin dito, kinakailangan ba payagan natin siya kagad na makasakay sa ibang prangkisa nang hindi po nase-settle itong napakaraming mga sagutin na ito at obligation na taong bayan na po ang nakakaalam nung tayo po ay nagkaroon ng malawakang public hearing dito. Hindi po dapat ganun lang. Kailangan pong masettle muna ito. Bakit hindi muna po nila kasi isettle, ayusin, bayaran ang dapat bayaran? Hindi yung makikisakay ka na lang na parang business as usual na lang, Mr. Chair. Ito po yung board ng aking privilege speech. At kung sinasabi po nila, Mr. Chair, na hindi po merger ito, hindi po acquisition, ito po circumvention lamang Mr. Chair. Alam po ba ninyo, yung IRR po ng Republic Act 10667, ito po yung Philippine Competition Commission. Under Rule 2, letter K, ang sinasabi po niya sa merger refers to the joining of two or more entities or to form a new entity, including joint ventures. Alam po ninyo, for purposes of assessing whether or not there is competition, pinalawak po ng IRR ng Philippine Competition ang definition ng merger para hindi po tayo maging technical lang, para walang makapag-circumvent ng batas. Ang nagsasabi pa po ng iba, hindi naman po acquisition yan, sabi niya. Kaya hindi na dapat magpaalam sa Philippine Competition. Hindi po totoo yun. Alam po ninyo, Mr. Chair, it is not only acquisition that will entail control over an entity because kahit na po, nandito po sa section 25 po ng Philippine Competition Commission, sinasabi po rito, Mr. Chair, in determining the control of an entity, the Commission may consider the following. Kung pupunta po tayo sa last sentence nun at idudugtong natin sa letter F, ganito po yung sinasabi. Control exists even when the entity owns 1/2 or less of the voting power of another entity when there exists rights or contracts which confer decisive influence on decisions of the entity. Ang totoo po, doon sa Philippine Competition Commission Act, Mr. Chair, nasa Section 4, dinefine din ang control. Ganon din po, sabi niya, sa letter F, control refers to the ability to substantially influence or direct the action or decision of an entity, whether by contract, agency, or otherwise. Yun po bang pagkakabili ng substantial stocks ng ABS-CBN, ng TV5, hindi po ba nagbibigay ng substantial control yun sapagkat ayon sa deal nila, Mr. Chair, ang ABS-CBN na po ang gagawa ng content. Wala na pong gagawing content ang TV5 at ang TV5 magbo-broadcast na lang. Bakit po nagkaganon? Parang mababiolate po yung Section 10 ng TV5 sapagkat yung rights and privileges na nakuha po dahil nakakuha na siya ng control, hindi po nila ipinagpaalam. Nasa Section 10 po yan, Mr. Chair. At yung word na merge dun sa Section 10 po, it was used in its generic sense, Mr. Chair. Hindi lang mo pinag-uusapan yung technicality ng talagang merger or acquisition. Ang sabi po sa definition na ginawa ng Philippine Commission, kahit na po joint venture, pagka-control ang nangingibabaw, ay kailangan po rin ay makikita rin po natin na control din po yan. At saka kaya ko po sinasabi na kinakailangan makialam ang Philippine Commission, Competition Commission, dahil hindi lamang po doon sa amount ng investment ang pinag-uusapan, Mr. Chair. Bakit po? Dahil po kasi sa Section 14 ng Philippine Competition Commission, kailangan pong tingnan ng PCC yung anti-competitive agreements. Nasa Section 14 po yan. Mandate po niya yan. Kailangan din po niyang makita kung merong abuse of dominant position. Nasa Section 15. Ito pong dalawang sections na to, Mr. Chair, kapag hindi po tiningnan ng Philippine Competition Commission, Ito pong dalawang ito have the object or effect of substantially preventing, restricting, or lessening competition. Yun po yung gusto nating tingnan. Yung po bang pagkakaroon ng control will have the effect of preventing, restricting, or even lessening competition. Ito po ay alang-alang sa interest ng consumers, Mr. Chair, kaya hindi po maliit na bagay na akala mo bigla na lang sasakay po sa isang may-ari ng prangkisa, kakalimutan lahat ng obligation, hindi na natin titingnan kung yung pagsanib ng dalawang yun makikita mo yung control at ang yung control magkakaroon na po ng monopolya at ang madidisgrasya rito yung interest ng ating mga consumers. Hanggang dito lamang po, Mr. Chair. Salamat po.
Honorable Marqueta. Okay, before you answer, Commissioner Cordova, we're supposed to present first all the resource persons before we go into the tuning pida natin yung hapong ito. So please hold your, you will have to answer the questions of Honorable Marcoleta later on. We will now ask the COMSEC to please acknowledge the second resource person that we invited in today's hearing.
Yes,
COMSEC.
Chairman, we have
Yes.
also on board the for the Securities and Exchange Commission, General Counsel Romuald Padilla.
Recognized.
Good afternoon, Mr. Chair, and the honorable members of the House Committee on Legislative Franchise and the Committee on Trade and Industry. Magandang hapon po. I am Romuald Padilla, the General Counsel of the Securities and Exchange Commission. On August 14, 2022, Mr. Chair, the Commission received a communication from the Committee on Legislative Franchise of the Honorable House of Representatives requesting for its comments on the investment agreement and the convertible note agreement between ABS-CBN and TV5. The Commission would like to thank the Honorable House of Representatives for the opportunity to provide information and comment on the subject matter in aid of legislation based on documents filed with and in the custody of the Commission. We would also like to inform the Honorable Committee that we already submitted our position paper earlier. Given the limited time for preparation, the Commission is only able to give initial and preliminary comments on the investment agreement and convertible note agreement between ABS-CBN and TV5, which are the subject matter of this afternoon's hearing. We therefore beg the kind indulgence and understanding of the Honorable Committee on this matter and respectfully request for additional time to prepare a more comprehensive position paper on the matter subject of this afternoon's hearing, if necessary. Please allow me, Mr. Chair, to start with the first part of my presentation, which is on information about ABS-CBN Corporation on record with the Commission. ABS-CBN is a corporation duly organized and existing under Philippine laws. It was incorporated on July 11, 1946 with SEC registration number 1903. Section 17 of the SRC and its implementing rules and regulations require public corporations to make a full, fair, and accurate disclosure of every material fact to the public through or by filing Form 17C with the Commission. Further, Section 72.1.9 of the SRC-IRR requires a public corporation to include in a registration statement or report such other relevant material information. Now, the records of the Commission show that ABS-CBN filed SEC Form 17C dated August 10, 2022, where it disclosed that its board of directors approved the acquisition or subscription of TV5 shares, which resulted in its execution of these agreements covering the following. First, ABS-CBN acquired 6,459,393 common shares, representing 34.99% of the outstanding capital stock of TV5 for an aggregate subscription price of 2.6 billion. Second, ABS-CBN also subscribed to a convertible note to be issued by TV5 in the principal amount of 1.8 billion. The convertible note is convertible into 5,500,448 additional common shares of TV5 on the maturity date, which is after 8 years from its issuance. In the event that the convertible notes are converted, ABS-CBN will own 49.92% of the outstanding capital stock of TV5. At this point, Mr. Chair, the Commission deems it proper and prudent to provide the honorable committees with a perspective on where the SEC is coming from in relation to the comments and initial assessment on the agreements that we will present this afternoon. In addition to being a company registrar under the revised corporation code, the SEC is the country's securities regulator mandated under the Securities Regulation Code to ensure full and fair disclosure about securities and to protect investors, among others. And it is in this context that on August 17, 2022, the SEC, after receiving the Form 17C filed by ABS-CBN, which is a publicly listed company, directed ABS-CBN to submit a copy of the investment agreement and the convertible note agreement to enable the Commission to assess and determine if applicable laws, rules, or regulations were complied with. The submission of the copies of the agreements, which should have been attached to Form 17C, will enable the SEC to evaluate and ensure that ABS-CBN's disclosure are not misleading or inaccurate. And more importantly, it will aid investors in making an informed decision. After an initial evaluation of these agreements, the Commission noted or observed that the disclosure was not full and complete as to the material fact and information provided therein that will enable the investors to arrive at an informed decision relative to ABS-CBN securities. Specifically, the Commission notes that the copies of the investment agreement and the convertible note agreement were not submitted or attached to the Form 17C filed by it. ABS-CBN, however, refused to comply with the directive of the Commission as it only submitted as an attachment to its letter dated August 18, 2022, an executive summary of the subject agreements instead of the copies thereof. The SEC therefore had to send another letter to ABS-CBN on August 19, 2022, reiterating its directive to submit the copies of the agreements in order for the Commission to render a complete evaluation of the transaction.
Chair, point of order. Mr. Chair, point of order.
The Honorable Vice Chair Varsagas recognized.
Well, I understand that the Securities and Exchange Commission officers are present. Then why is it that Attorney Padilla is the spokesperson of the Securities and Exchange Commission? I think it would be but proper that it will be the Securities and Exchange Commission who shall speak on their findings, on their comments, but not the Philippine Competition Commission.
ComSec, who the Attorney Padilla is speaking for?
Sir, he is the General Counsel from the Securities and Exchange Commission.
Not
And
from
they are,
the Philippine Competition Commission.
No,
yes,
SEC.
yes, sir. SEC.
SEC.
Okay, so continue. Sorry, I thought that he was representing the Philippine Competition Commission.
Okay, proceed, Attorney Padilla.
Thank you, Your Honor. So, after the SEC therefore had to send another letter to ABS-CBN on August 9, 2022, reiterating its directive to submit the copies of the agreements in order for the Commission to render a complete evaluation of the transaction, consistent with its mandate to ensure compliance with applicable laws, rules, and regulations, and in line also with ABS-CBN's duty to make a full, fair, and accurate disclosure to the public of every material fact. And it was only on August 22, 2022, after the SEC issued a show cause letter, that ABS-CBN submitted redacted copies of the investment agreement and convertible note agreement. So given the very limited time within which to review these agreements, Mr. Chair and honorable members of the committee, the Commission can only provide and present its preliminary comments and assessment on the same as follows. First, there is a need for the Commission to further examine the provisions of this agreement to determine whether the shares, notes, and transactions covered therein are exempt from registration under the applicable provisions of the SRC. The conduct of a further investigation will also enable the Commission to assess whether ABS-CBN fully, fairly, and accurately disclosed material facts and events surrounding the agreements. Second, as regards the convertible note agreement, the following were observed as the salient features of the convertible notes that was issued by TV5 to ABS-CBN. The issue price is 1,839,899,856. The convertible note units is 5,500,448 units, free from all encumbrances and document and stamp duties. ABS-CBN, being the note holder, is entitled to payment of interest in each interest payment due. The interest equivalent to the amount per share declared as dividends on TV5 on one common share, with TV5 procuring that such interest shall be paid in cash on the same date of the relevant dividend distribution or payment of any corresponding dividend distribution or payment on the common shares of the issuers. Another feature is that the convertible note is participating and entitled to payment of interest measured by dividends payable on common shares. However, investor is not entitled to vote, to receive dividend or other rights as stockholder until conversion. Moreover, as a debt, it has preference over holders of common shares in case of liquidation of the company and ranks pari passu with other direct, unconditional, and secured obligations of TV5. Another feature, transfer and assignment of convertible note shall require prior written consent and may not be made in favor of restricted persons. Moreover, TV5 has agreed not to issue, without the prior written consent of ABS-CBN as a note holder, any additional conversion or common shares, make any increase, reduction, or redemption of share capital, share premium account, or capital redemption reserve, resulting in repayment of money to shareholders, or reduce any uncalled liability in respect to capital. Finally, the last feature is that ABS-CBN is entitled to exercise its conversion right, with the convertible note being converted to all or portion of the conversion shares, either first on maturity date, which is 8 years after the issuance of the convertible note, or second, on the occurrence of an event of default. Now, Mr. Chair and members of the Honorable Committee, our initial evaluation of the provisions of the agreement enable us to identify the following issues, which, from the perspective of the SEC as a securities regulator, needs to be addressed by ABS-CBN, a publicly listed company, to the satisfaction of the Commission. First, on the interest rate, a convertible note having features of usually provides for an interest rate. The convertible note agreement states that interest shall be equivalent to the amount per share declared as dividends by TV5 on one common share, with TV5 procuring that such interest shall be paid in cash on the same date of the relevant dividend distribution or payment of any corresponding dividend distribution or payment on the common shares of the issuers. Now, payment of interest is dependent upon the declaration of dividends by TV5. It should also be noted that such declaration of dividend is equally dependent on the existence of unrestricted retained earnings. However, looking at the current financial state of TV5, the SEC noted that it incurred net losses of 1.2 billion, 1.6 billion, and 2.5 billion for the years 2021, 2020, and 2019 respectively, based on its 2021 audited financial statements. Moreover, the company reflected a retained earnings deficit of 1.2 billion and 1.6 billion in 2021 and 2020 respectively. So given this set of facts, the Commission sees that the agreement is disadvantageous to ABS-CBN, including its investors, in the sense that it cannot earn interest until TV5 recovers from such deficits, and unless it will have unrestricted retained earnings. Second, on the exercise of conversion right at maturity date or 8 years after the issuance of the convertible note. Now, while the parties can stipulate on the date of maturity of the debt, the Commission finds it unusual that ABS-CBN agreed to exercise its conversion right only after 8 years, as opposed to being able to exercise such conversion right at a shorter or reasonable period of time. This effectively prevents ABS-CBN from taking advantage of the equity feature of this security instrument, as it is unable to convert the same at the opportune time, which may result in the acquisition of a higher number of shares. This, again, to the mind of the Commission, is disadvantageous to ABS-CBN and to its shareholders, especially minority investors. Third, the exercise of conversion right is upon occurrence of an event of default. The Commission finds it unusual that ABS-CBN accepted and agreed to exercise a right to convert all outstanding convertible notes into shares on or after the occurrence of an event of default, instead of deciding to remain as a creditor of TV5, where it can demand payment of the amount due and enjoy preference together with other creditors. This gave the Commission an impression that for ABS-CBN, being a shareholder of TV5 is more important than being able to collect a debt from a defaulting entity. This is a concern on the part of the SEC, who is mandated to protect the investing public, which includes the investors of ABS-CBN, a publicly listed company. Fourth, the ownership of ABS-CBN of 49.92% of TV5's total voting and outstanding capital stock. The exercise by ABS-CBN to convert all the convertible note into shares under the convertible note agreement will, together with the initial investor shares which it acquired under the investment agreement, will result in ABS-CBN holding or owning 49.92% of the total voting and outstanding capital stock of TV5. The resulting capital and shareholding structure of TV5 after closing and conversion of the investment agreement and convertible note agreement will make both MediaQuest Group of TV5 and ABS-CBN owners of TV5 with equal percentage of 49.2%. We see this, or the SEC sees this as a potential risk for TV5, especially in relation to its compliance with the 30% public ownership provision in its franchise law, as will be explained in a while. Finally, Mr. Chair and members, honorable members of the committees, please allow us to present our comments on the agreements in relation to the legislative franchise of TV5, which is RA number 11320. Section 11 of RA 11320 requires TV5 to offer to the public at least 30% or a higher percentage that may hereafter be provided by law of its outstanding capital stock in any securities exchange in the Philippines within 5 years from the commencement of its operations. Now, pursuant to the investment agreement, ABS-CBN acquired 6,459,393 common shares, representing 34.99% of the outstanding capital stock of TV5 for an aggregate subscription price of 2.16 billion. Moreover, ABS-CBN also subscribed to a convertible note to be issued by TV5 in the principal amount of 1.8 billion. The convertible note is convertible into 5,500,448 additional common shares of TV5 after 8 years from its issuance, which will result in the ownership by ABS-CBN of 49.92% of the total voting and outstanding capital stock of TV5. Now, based on the 2021 General Information Sheet of TV5, it has an authorized capital stock of 20 million, divide 18 million of which is common and 2 million of which is preferred. And out of the 10 million, 10 million of the 18 million common shares is already subscribed, thus leaving only 8 million unsubscribed shares. The remaining 8 million unsubscribed is sufficient to enable the acquisition of 6,459,393 TV5 shares by ABS-CBN under the first agreement, which is the investment agreement, and will, however, leave TV5 with only 1,540,607 unsubscribed common shares. However, with the implementation of the convertible note agreement, TV5's remaining unsubscribed common shares of 1,540,607 will no longer be sufficient to cover the conversion of convertible notes into of 5,500,448 additional common shares upon the exercise by ABS-CBN of the said option. In such case, and considering that under the investment agreement and convertible note agreement, ABS-CBN will ultimately be holding or owning 49.92% of the total voting and outstanding capital stock of TV5, which TV5 agreed to. TV5 then will have to explain to the Congress how it plans to or comply with the 30% public ownership requirement given the available shares. In addition, Mr. Chair and honorable members of the committee, it should also be pointed out that Section 10 of RA 11320 prohibits TV5 from selling, leasing, transferring, granting, the usufruct of, or assigning its franchise or the rights and privileges freely granted without the prior approval of the Congress, and is obliged to inform the Congress of any sale, lease, transfer, grant of usufruct, or assignment. In relation to the investment agreement, while the SEC is of the view that there was no merger of TV5 and ABS-CBN under the provisions of the revised corporation code, the Commission suggests, however, that the matter on controlling interest be looked into by the Congress, and in this regard, the Commission will defer to the Congress on what constitutes controlling interest in determining whether there is a need for its prior approval as mandated in its franchise law. The SEC would also like to point out, however, that under Rule 3.1.8 of the SRC-IRR, control is defined as the power to determine the financial and operating policies of an entity in order to benefit from its activities, and it is presumed to exist when a parent entity owns directly or through subsidiaries and associates more than 50% of the voting power of an entity, and it also exists when the parent entity owns 50% or less of the voting power of an entity, but has any of the following powers. And 3.1.8.3 provides power to appoint or remove the majority of the members of the board of directors or equivalent governing body. And 3.1.8.4 provides for the power to cast the majority of votes at the meetings of the board of directors or equivalent body. In closing, Mr. Chair and honorable members of the committee, we would like to reiterate that the foregoing comments and inputs of the SEC are products of an initial evaluation given the limited time and was made solely in the context of the Commission's mandate as securities regulator tasked to ensure compliance with applicable laws and regulations. The Commission respectfully submits that a further thorough examination of the provision of these agreements, including all the relevant attachments and documents, must be made. Until then, and subject to the explanation that will be provided by ABS-CBN on the matters that were raised by the Commission cannot make, as yet, any final determination on whether any violation was made by ABS-CBN when it executed the investment agreement and convertible notes agreement. Thank you, Mr. Chair and honorable members of the committee. Good afternoon.
Chair, good
Thank
afternoon.
you.
Mr. Chair, good afternoon. This is Kong Rida Robes.
Yes, Congrida.
Yeah, good afternoon, Mr. Chair. First, I'd like to thank all the resource speakers for joining us today. May I request for the position paper of the Security Exchange Commission, so maaral din natin ng mga members yung kanilang stand towards this issue being tackled today. Yun lang po,
Thank you.
Mr. Chair.
Yes, I just like to inform everyone that the committee just today, we received the position paper from SEC. And I direct the COMSEC to please send it to the individual emails of all.
Putol na naman.
Much for presentation. And again, COMSEC, please forward to the respective emails the position paper of SEC. We now proceed to the third resource person. COMSEC, please recognize the third resource person.
Mr. Chair, I apologize.
COMSEC.
Sir, Congresswoman Nograles wishes to be recognized.
Congresswoman Nograles.
Mr. Chair, if I remember, will the NTC also be giving us the copy of the Memorandum Order 3-06-2020?
Yes, yes. Everything that will be given to us will be for all members of both committees will be furnished.
Thank you, Mr. Chair.
So thank you very much, Congresswoman Nograles. COMSEC, the third resource person and the last resource person before we go into the interpretation of our members. Those that would like to interpret, magpalista na kayo. We have already 5. Of course, led by the Honorable Marcoleta, Vice Chair Barsaga, the Congressman Teves, and Congressman Anthony Gole. So now we proceed. The third resource person, COMSEC.
Thank you, Mr. Chairman. We have from the Philippine Competition Commission, Commissioner Johannes Benjamin Bernabe. Your honors.
Go. Is he here?
Good afternoon, Mr. Chair. Yes.
Yes, yes, Attorney Bernabe. You have the floor.
Thank you, Mr. Chair, and a pleasant afternoon to all the honorable members of the Committee on Trade and Industry and the Committee on Legislative Franchises, including, of course, their respective chairpersons. Philippine Competition Commission focuses on the impact on competition and consumer welfare of the transaction. So it is really with regard to the acquisition of shares by ABS-CBN in TV5 that the mandate of the Competition Commission is focused on. Now, we submitted a position paper earlier, I believe yesterday, to the Honorable Chair and the Secretariats, and I hope that that will be circulated as well to all the members of the committees herein present. We also have had no ample opportunity to look at the details of the transaction, primarily because up till now, ABS-CBN and TV5 have not notified the Commission of their transaction. Under the law and under our rules, they do have 30 days within which to notify us if the transaction happens to be a notifiable transaction, meaning that it meets the thresholds provided for in the law, the IRR, and other relevant legislation. So we have two issues before us as far as the Commission is concerned. First is whether the transaction is notifiable under the law and under our rules. And secondly, regardless of whether it is notifiable, and I will explain the reasons for this broad concept later, regardless of whether it is notifiable, whether the transaction is likely to result in a substantial lessening of competition that we can review and thereafter prohibit or subject to conditions. So if you will allow me, Mr. Chair, I'd like to discuss the first issue, which is the notifiability of the transaction. Unlike the SEC, we do not have a copy of the investment agreement and the other related documents. What we have are publicly available information, which have already been articulated before the committees. Based on these publicly available information, it appears to be that the transaction is not notifiable. It does not meet the transaction value under the Bayanihan to Recover as One Act or Bayanihan 2. If you will recall, under this law, Congress required the PCC for a period of 2 years or until September 15 or thereabouts 2022 to review only mergers or acquisitions with a transaction value of more than 50 billion pesos. This means that either of the parties must have assets or revenues in the preceding year of more than 50 billion. This is what we refer to as the size of party test. And secondly, that generally, because this transaction is a transaction within the Philippines, that the entity to be acquired must have assets or revenues in excess as well of 50 billion pesos. This is known as the size of transaction test. Now, additionally, the requirement under the PCA where the transaction involves an acquisition of shares remains applicable. That is that the transaction must result in more than 35% of the voting shares being transferred to the acquiring entity. So with regard to the present transaction, insofar as the size of party test, the aggregate value of the Lopez Group assets in the Philippines amounts to approximately 456 billion pesos, which is in excess of the 50 billion threshold under the Bayanihan to Recover as One Act. Meanwhile, PLDT's aggregate value of assets in the Philippines amounts to 525 billion pesos, more or less, and therefore the size of party test is met. With regard to the second test, the size of transaction, TV5's value of assets in the Philippines only amounts to 7 billion pesos, which is below the 50 billion peso threshold. And as the SEC mentioned earlier, their revenues in the past 3 years have been in the red, meaning that their revenues have been in the form of losses, and these range from 2.5 billion pesos to 1.2 billion pesos in the last 3 years. Now, in the same vein, the transaction also relates only to acquisition of shares that would result in ownership of 34.99% of voting shares, and therefore not meeting the requirement of the acquisition of at least 35% of the voting shares in order to qualify under this size of transaction test. And therefore, under this second test, it appears that the transaction is not notifiable. Now, even if it is not notifiable, because it does not meet the thresholds provided under the law and under our IRR and under Bayanihan to Recover as One Act, it does not preclude the parties from voluntarily notifying the PCC under Section 3.2 of the PCC Rules on Merger Procedure within 30 days from the execution of their investment agreement. The Commission, in its discretion, may give due course to such voluntary notifications subject to the review period of a total of 135 days, 45 days for phase one, and if there is an indication of a substantial restriction on competition, which necessitates a deeper analysis, we can have another 90 days for a phase two review. Now, suppose the parties do not voluntarily notify the Commission. Can the PCC conduct a review of the transaction on its own initiative or motu proprio? The answer is yes. Section 16 of the Philippine Competition Act gives the Commission broad powers to review mergers and acquisitions based on factors it deems relevant. Section 13 of our Rules on Merger Procedures further provides the trigger when this motu proprio review may be exercised. That is when the PCC has reasonable grounds to believe that the transaction is likely to substantially prevent, restrict, or lessen competition in the market. As an update on this and in the exercise of our authority, the Commission and Bank has directed its Mergers and Acquisitions Office, the unit under the PCC, which conducts merger review, to make an initial assessment of whether the transaction is likely to substantially prevent, restrict, or lessen competition, and as such, whether the Commission has reasonable grounds to initiate a motu proprio review. Note that these reasonable grounds is the legal standard by which we can initiate a motu proprio review, and therefore, it is important that we get a report and a recommendation that the Commission and Bank can act upon based on the initial assessment of our Mergers and Acquisitions Office. Now, suppose either the parties voluntarily notify or the Commission undertakes a motu proprio review of the transaction, what will we be looking at? Well, as Congressman Marcoleta mentioned earlier, we will be looking at whether the transaction has the object or effect, or in more common terms, layman terms, is likely to substantially lessen competition. Now, we look at, from a competition perspective, two dimensions. These two dimensions are, first, are the parties competitors? Are they operating in the same segment of the value chain? And if they are, what these markets are, what these lines of businesses in which the acquiring and acquired entities compete, and whether the resulting concentration of market shares in these markets will cause a substantial lessening of competition. So we have had an initial look at the lines of businesses that may indicate a potential competition or overlap between ABS-CBN and TV5. And we noted that whereas TV5, prior to the investment agreement and prior to the operationalization of that investment agreement, is also involved in content production and content distribution and programming, this overlaps with ABS-CBN and its subsidiaries' main business now of content production, development, distribution, and programming. This may involve entertainment shows, talk shows, documentaries, news, and films. Now, there is a parallel transaction involving Signal's acquisition of Sky Cable. And we all know that the parent companies of these two companies are also the companies involved in the transaction under review by the committee today. Now, moving on, the second dimension that we examine from a competition perspective is, apart from the segments in the value chain where these entities may be competing, we also look at whether or not they are actually suppliers and consumers for certain products. Meaning, do they have a vertical relationship such that the inputs of one entity are derived from the output of the other entity? So in this kind of relationship, we look at the vertical effects of that kind of input and output relationship. If ABS-CBN is a content developer, will its output in terms of content and shows and all that now be limited to TV5 under the investment agreement? Will it now no longer be available in the other media platforms through which they were previously viewed, whether these are in traditional media or in social media platforms? And therefore, if this is going to happen, will there be less choice for consumers to view these programs? And part of the competition considerations is to ensure that consumer welfare is not prejudiced by any transaction that comes before the review of the commission. Now, is it also possible that this content, by being provided to TV5, will now allow TV5 to compete more effectively against incumbents in the TV and radio broadcasting space? When ABS-CBN was closed in 2020, its other competitor in the market for TV and radio broadcasting, GMA7, assumed dominance of the broadcasting services industry. Why do we say this? Well, when ABS-CBN and GMA7 were both operating, they had between 35 to 40% of the market share each for TV and radio broadcasting, or at the very least for TV broadcasting. When ABS-CBN was shut down, there was a diversion of those who patronized and used ABS-CBN. There was a diversion in favor of GMA7, such that the market share of GMA7, depending on the entities which were reviewing market share analysis for this sector, ranged from 53.6% to 65%. So, using the presumptive evidence that we can accord to such percentages, as far as we are concerned, GMA7 became the dominant incumbent insofar as TV and radio broadcasting services are concerned. Now, with ABS-CBN buying into TV5 and providing the content that TV5 apparently needs, would TV5 now be able to impose a competitive pressure on GMA7's dominance such that it effectively fosters competition in the market? These are considerations that we have to look into. And the parallel transaction involving the acquisition of shares by Signal and Sky Cable, apart from having its own impact on competition within the market for cable TV or satellite TV, in and of itself adds further complications to the examination of the impact on competition of ABS-CBN's investment in TV5. Now, as I said earlier, These are questions which we will have to address in the context of a review, whether triggered by a voluntary notification by the parties or by the Commission motu proprio exercising its initiative or power to conduct reviews of mergers which may have an impact on competition. We cannot answer these questions and issues now. To do so would be premature. We would have to do economic analysis, market analysis, and examine the legal, commercial, and economic context in which these parties operate, in able to be in a position to make findings and conclude on whether or not the transaction will substantially lessen competition in the market. Now, a question is raised by some on whether the first issue on non-notification to the PCC of the acquisition is a ground for the transaction's prohibition and cancellation. I can only point to Section 17 of the Philippine Competition Act, where it says that agreements consummated in violation of the requirement to notify, where they are so required, will result in the agreement being considered void and the parties subject to an administrative fine of between 1% to 5% of the value of the transaction. However, as I mentioned earlier, at least based on a preliminary evaluation by our Mergers and Acquisitions Office, the transaction does not seem to be notifiable. Now, at the end point, if we conduct a review, and it so happens that we find that the transaction substantially lessens competition in the market, what can the PCC do? First, under the law, we can prohibit the transaction. Alternatively, we can also subject the transaction to conditions to remedy the effect on competition in the market, the negative effect on competition in the market. And in this case, parties can also come forward and voluntarily offer commitments, as we call them, to remedy that anti-competitive impact. Again, to emphasize, the parties have not contacted the PCC about this deal. We do not have a copy of the investment agreement, and we are basing what we are initially presenting before the Commission on publicly available data and the information that we have called as part of our initial assessment. Thank you, Mr. Chair.
Mr. Chair.
Thank you very much,
Mr.
Commissioner
Chair.
Bernabe. So now we proceed. That's the third resource person. No? So we now can proceed to the interpellation. Meron na po 5 nagparista. The Honorable Marcoleta, then followed by the Honorable Lagman, then followed by the Honorable Teves, then the Honorable Vice Chair Barsaga, and the Honorable Anthony Godes. Kung meron po magpaparista, please inform the Secretariat. The Chair recognizes the Honorable Rodante Marcoleta.
Thank you, Mr. Chair. Question to the Commissioner of the PCC. He mentioned the 2 kinds of tests. One is the notification test. While he mentioned Section 17, I think he failed to explain to us that parties to the merger or acquisition agreement referred to wherein the value of the transaction exceeds 1 billion pesos are subject to notification. It is already, as mentioned by him, in Section 17. And based on publicly available information, I think the value of the acquired outstanding stock of TV5, Mr. Chair, is over 2 billion pesos. Is this not a basis of notification, Mr. Commissioner, considering that the threshold value here is only 1 billion pesos?
May I answer, Mr. Chair?
You may answer.
Thank you, Mr. Chair. Honorable Marcoleta, there is a provision in the Bayanihan Act which increased for 2 years, for a 2-year period, the value of transactions that may be reviewed by the PCC to 50 billion pesos. That will expire on September 15, if I'm not mistaken. But for now, we cannot review any transaction which falls below a value of 50 billion pesos. And this is because the House of Representatives and the Senate passed that law in 2020.
I know that, Mr. Chair, but considering Section 17, when it mentions a threshold amount of 1 billion pesos, where agreements can be prohibited if it exceeds 1 billion pesos, I suppose, why did you not look into that, considering that the publicly available information already suggested that the acquisition of substantial shares of TV5 exceeded more than 2 billion pesos? This is the point here, because Section 17 is about compulsory notification. That is only my point. If you can explain that, because it talks about 1 billion pesos only.
Mr. Chair, if I may.
Please proceed.
Yes. The Bayanihan 2 Act precisely modifies or suspends the operation of that threshold provided in Section 17, Your Honor. So if we proceed to review this transaction, or if we compel ABS-CBN and TV5 to notify us, we would be in violation of Bayanihan 2. But just to clarify, Mr. Chair, even if this transaction is not notifiable, we can initiate on our own a motu proprio review of the transaction, but we have to have a reasonable basis. And that reasonable basis will be something that we will discuss and deliberate upon when our Mergers and Acquisitions Office comes back to the Commission and Bank with the report and recommendation by the first or second week of September.
Mr. Chair, the reasonable basis that the good commissioner is talking about is the definition of control itself, which appears under Section 4 of the PCC Charter. And it was also exemplified also under Section 25 on control of an equity, where control also exists even when entity owns 1/2 or less of the voting power of another entity, when there are 3 conditions here, Mr. Commissioner. And the last one, I will emphasize that, letter F, when there exist rights or contracts which confer decisive influence on the decisions of the entity. This is where you should come in, because if that control, even if by way of stocks it's even lesser or acquisitions even lesser, but it is not the question of value only that manifests control, Mr. Chair and Mr. Commissioner, because this particular provision of your charter elicits conditions where control can come in. You made mention about vertical merger earlier, which is a condition between companies that are along the same supply chain, and this is correct. But maybe you should also consider that these 2 merging companies or companies that are now trying to be in partnership, they're also exercising horizontal merger, Mr. Chair, because horizontal merger is a condition between companies that directly compete with each other. So you will see, Mr. Commissioner, it's not only vertical situation that is involved here. It is horizontal merger as well, because of the control that ABS-CBN might play here. Can you imagine? ABS-CBN will be the one supplying the contents already, and TV5 will not do that anymore. And so it is like, giving away your right to produce contents, and it is only ABS-CBN who is going to do that. In other words, when ABS-CBN lost its franchise to do that, to produce contents, we are now giving it another vehicle to do just that. So there are so many aspects that we should review here. And competition-wise, Mr. Commissioner, it is of course your bounden duty to look into the consumer welfare. It is very obvious that the dominance of ABS-CBN in contents will again be a forceful factor here that you should also consider. And your mandate is very clear that any anti-competitive agreement should be looked into, and even the abuse of dominant position should be looked into if the object or the effect of which might lessen or even prevent competition. Ito yung dapat nating tingnan. Not only on the issue of notification, maybe they have their ways to evade that and circumvent that, but the ultimate analysis will be on whether or not the combination between these two networks will stifle competition and it will not inure to the benefit of the greater consumers. Mr. Chair, Mr. Commissioner, thank you.
Mr. Chair, may I offer a quick reaction to the Honorable Congressman?
Please do.
Thank you, Mr. Chair. Thank you, Congressman Marcoleta, for your very perceptive insights. I would limit myself to two issues you have raised. The first one is on the matter of control and whether that is sufficient to vest in us jurisdiction. I think the question of control is what we look at for purposes of considering this transaction an acquisition. Okay. It is not a merger from our perspective, but it is an acquisition because there is a purchase of shares. You know, whether or not it breaches the 35% threshold or not, it is an acquisition of shares. The 35% threshold only relates to the question of whether it should be notified. And as you noticed, ABS-CBN only pegged its purchase of shares at up to 34.99%, below the 35%. Now, whatever the reason is, that is beyond what we would wish to comment on at this point. But definitely, the reference to the matter of vestiges or badges of control, to our mind, qualifies the transaction as an acquisition. Now, the second thing is the fact that it is an acquisition. Does it already form a reasonable basis for us to initiate a motu proprio review? If I may clarify, the basis for conducting a motu proprio review will have to also include an initial assessment of whether the transaction is likely to cause a substantial lessening of competition based on a very cursory examination of the facts. And that is something that we are in the process of doing. And the determination of a substantial lessening of competition is an economic analysis at the end of the day. But we are expediting it so that we can have a recommendation on whether or not to open a motu proprio review of the transaction if the parties do not choose to voluntarily notify the same. On the second issue with regard to vertical effects and horizontal mergers, you're absolutely right, Congressman Marcoleta. We are going to look at both. We are going to look at the markets where ABS-CBN and TV5 are competitors. And I enumerated in part what those are. You are also correct that we are going to look at the vertical effects of the merger, the fact that they are in a supply chain relationship, one developing content and the other one using that content for purposes of broadcasting. Now, I mentioned earlier that the parallel transaction of Signal acquiring Sky also adds further complications. And we will be looking at what we call as the conglomerate effects of this acquisition. Conglomerate because these are conglomerates. And that is a unique feature of the Philippine economy, that many of our entities are part of conglomerates. And we will be looking at that as well if we conduct a review. So rest assured, Your Honor, that we will be looking at all of these matters very carefully, including what may result out of the transaction as a possible dominance of ABS-CBN in terms of content development, and how it may be relating to a foreclosure of other markets for its airing or for the sourcing of content by TV5 itself. So we will be looking at these matters, Your Honor.
You
Thank
may
you.
look into also market extension merger, Mr. Commissioner, and product extension merger. Thank you.
We will do so, Your Honor. Thank you.
Mr. Chair,
Okay.
just
So
a
now-
clarification.
Yes.
Well,
Yes, no, Vice Chair Barsaga.
well, I was present even at the time we started the hearing. And I just remember, I'm not sure whether or not our source persons have taken their oath. So I would like to verify whether or not these source persons have already taken their oath before our committee.
Shown to that they have not taken their oath. Is there?
I
Do
move
you wish
the
that?
source persons be required to take their oath.
Okay, on the motion of the Honorable Vice Chair Barsaga, may I direct the COMSEC to please administer the oath to our resource persons.
Yes, Mr. Chairman, may I ask the resource persons from the Philippine Competition Commission, the Securities and Exchange Commission, and from the NTC to please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth before these joint congressional inquiries? So help you God.
I do.
Thank you.
So thank you very much, COMSEC. So are we done, Honorable Marcoleta? Tapos na po kayo, so we can move to the next interpreter. The Honorable Marcoleta. So I don't think he's online. So now we can proceed, no?
Mr. Chair, pagbigyan ko si Congressman Barsaga, siya na muna.
Okay, ang susunod na kalista si the Honorable Lagman, sa listahan. So
okay.
the Honorable Edson Lagman is second.
Okay.
Honorable Lagman.
Someone is trying to call you.
Honorable Lagman, you have the floor.
Thank you, Joint Chairman. Before I start with my interpellation, may I be allowed to read into the records my letter to Speaker Romualdez, dated 22 August 2022, which would really set the tone and preliminarily join the issues for purposes of this inquiry. May I proceed, Mr. Chairman?
Please proceed. You have 20 minutes for your interpretation, including the joint statement.
Honorable Martin J. Romualdez, Speaker, House of Representatives, Batasan Complex, Quezon City. Dear Speaker Romualdez, I write on behalf of my constituents and concerned citizens about the looming House investigation, which may result in the derogation of press freedom and free speech, the bedrock of democratic governments. I refer to the recently announced transaction between TV5 Network, Inc. and ABS-CBN Corporation, which has generated some innuendos which must be clarified and corrected. First, the deal is not a merger, where one entity absorbs another or two entities fuse to form a new one, as defined by the Philippine Competition Act, or RA number 10667. TV5 and ABS-CBN remain separate and independent juridical entities. Neither does acquisition obtain as defined in Section 4 of the Philippine Constitution Act, because ABS-CBN does not acquire control of TV5. Second, The contract is an investment agreement wherein ABS-CBN invests in TV5 by putting in 2.61 billion in exchange of 34.99% of TV5's voting stock and an additional 1.84 billion in convertible note, which can be exchanged for additional voting shares only after 8 years and will increase ABS-CBN's stake in TV5 to only 49.92% or less than a controlling absolute majority. And this is still inquiry or subject to future events and also subject to requisite approvals. Third, there is no franchise issue. Section 10 of TV5's renewed franchise under Republic Act number 11320 is not violated by the transaction because there is no sale, lease, transfer, or grant of the use of frac or assignment of TV5's franchise to ABS-CBN. Moreover, there is no merger or transfer of controlling interest in TV5. Fourth, the transaction of 4.45 billion is less than the transaction value threshold of 50 billion under the Bayanihan to Recover as One Act or Republic Act number 11494. Consequently, the said transaction is exempt from the compulsory notification and approval by the Philippine Competition Commission. Fifth, Memorandum Order number 003-06-2022 of the National Telecommunication Commission is constitutionally infirm, arbitrary, and vague for the following reasons. One, it violates the constitutional right of TV5 and ABS-CBN to enter into a contract which is not contrary to law, morals, good customs, public order, or public policy. There is no rhyme, no reason to disqualify an entity from contracting simply because it has outstanding obligations to the government. Two, the NTC memorandum is a usurpation of the legislative power. It adds and imposes a restriction on a franchisee like TV5, which is not in its legislative franchise. Three, the NTC memorandum is arbitrary because it discriminates against entities which have got outstanding obligations to the national government and local government. Unquote. It is also akin to a class legislation which infringes on the Constitution. Four, the NTC memorandum is vague because it lacks the requisite standards for determining what is the nature, extent, and status of the so-called quote outstanding obligations. Six, the TV5 ABS-CBN transaction enhances fair competition in the television and broadcast industry. Without a franchise, ABS-CBN ceased to be a major player in the industry. TV5 has not achieved major player status. One television network presently dominates the industry. With the recent infusion of ABS-CBN investment in TV5, the playing field approximates leveling. Healthy competition will ensue as networks would compete for revenues and viewership. Competition also improves quality of shows, news coverage, commentary, and entertainment. Not even the current dominant network expressed opposition to the transaction. Seven, in the subject joint venture agreement, ABS-CBN, which doesn't have a franchise, creates and produces content, while TV5, which has the franchise, broadcasts the shows. Mr. Speaker, there is absolutely nothing wrong with that arrangement. What is definitely errant is when authorities trample on the freedom of expression and of the press. Thank you for your kind consideration and appropriate action. But it will yours, Edsel Sinagman. Joint Chairman, thank you for giving me this opportunity to place on record the subject letter. And I am certain the joint chairman will not allow the respective committees to be used to trample press freedom and free expression. Thank you, Mr. Chairman, Mr. Chairman, and may I proceed with my interpellation.
Please proceed.
May I request from Commissioner Cordoba, or may I know why he has not brought with him a copy of this memorandum order number 003-06-2022.
The Honor NTC Commissioner Cordoba is recognized.
Yes, Mr. Chairman, Congressman Lagman. We have a copy, Your Honors, and we will furnish this to the Honorable Committee, Your Honors.
The committee should have, the joint committee should have been furnished well ahead of this memorandum, because the memorandum is only a one-page memorandum. Is that correct, Mr. Commissioner?
Yes, Your Honors, it's a one-page memorandum.
And it is signed solely by Commissioner Cordoba. Is that correct?
That is correct, Your Honors.
And maybe know what is the date of this memorandum order?
Your Honors, it's Mr. Chairman, it's dated 23 June 2022.
Why is it that until now it has appeared in the website of the commission?
Actually, Your Honors, what we did was we sent it to all the broadcasters by email, Your Honors, and furnished also to the KBP.
Okay.
That is
Now,
the industry organization of all broadcasters in the Philippines, Your Honors.
May we know, Mr. Commissioner, if there is any law, decree, or ordinance which would disqualify a person, whether natural or juridical, from entering into a contract simply because it has so-called outstanding obligations with the government?
Actually, Your Honors, the reason why we issue this memorandum is to enforce compliance of obligations of existing entities. Because, Your Honor, I believe, for example, when you talk about the sale of real property, the Register of Deeds will not register the transfer of the property if the real property taxes are not paid, and the owner of the property is not able to get clearance from the Bureau of Internal Revenue. So, to enforce compliance po with the payment of taxes and other obligations of entities, and to help the national government, considering that there is a need for collection, especially because of COVID, kaya po we issued this memorandum order, Your Honors.
Does that answer the question, Mr. Chairman? And I think the NTC is it's not a general collection arm of the government. My question is there a law, decree, or ordinance which disqualifies a person, whether natural or juridical, from entering into a contract simply because it has outstanding obligations with the national and local governments?
Your Honors, we are in the position, it is our position that a franchise is a privilege, Your Honor. So we can impose additional obligations on part of the franchise holders or owners when they enter into contracts, Your Honor.
We will go to that later, but the answer is there is no law. Is that correct, Mr. Chairman?
Your Honors, I think it's the general principle po that you have to first pay your obligations with the government to be in good standing as a corporation or as an entity before you can enter into contracts, especially in this case with the franchisee, which was given by Congress, Your Honors.
Is that policy you are saying rendered in black and white in any statute or issuance?
I'm not aware. I'm not aware, Your Honors.
As a matter of fact, under the Civic Code, there are only 3 kinds of persons who cannot give consent to a contract. One, unemancipated minors. Two, insane or demented persons, or deaf mutes who do not know how to write. And this is under Article 1327 of the new Civil Code. And you don't have to confirm this, Mr. Commissioner, because that is the law.
Yes,
Now, can a memorandum order of the NTC amend the franchise issued by Congress?
Actually, Your Honors, it can add obligations, Your Honor, especially since that is a privilege granted by the state. And in this case, the parties are franchise holders, and they get a permit from the national government for the use of the frequencies which is owned by the national government. So as part of that contract with the government, we can put in obligations para po maging sila in good standing sa national government, Your Honor.
Obligations in addition to the basic restrictions and limitations imposed in their franchise by the Congress of the Philippines. Is that correct?
We're coming from the general principles po of yung pong pagbigay namin ng property of the state to them, which is the frequencies, and they use it for commercial purposes. Then we can include obligations in or conditions in giving them that right, that privilege to use those frequencies, Your Honors. Well,
I beg to disagree. In your memorandum 00306/2022, the first number says, in addition to the conditions and limitations provided in the grantee's legislative franchise on mergers and acquisitions. I don't think the NTC has the power to amend or impose new restrictions to a legislative franchise. This is a derogation of the legislative power, and we cannot allow Congress, we cannot allow NTC to make a mockery of the franchises issued by the Congress. I suppose, Mr. Commissioner, you should be able to review the extent of your authority. Just for the sake of clarity, your memorandum order consists of only 4 paragraphs. Is that correct? Do you have a copy of your memorandum, Mr. Commissioner?
Yes, Your Honor. I have a copy, Your Honor.
Could you just refer to your copy and confirm that it is consisting of only 4 paragraphs from the opening statement of in the interest of the service up to approval prior to the consummation?
Yes, Your Honors. The first paragraph would be the introduction, Your Honors, and then the provisions would be 3 numbers, Your Honors.
Well, Mr. Chair, I reserve my other questions because I have a question to the Philippine Competition Commission. Can I proceed, Mr. Chair?
Please proceed. 5 minutes. You have 5 more minutes. Please proceed.
Okay. Well, under the bayanihan to recover as one, the 4.45 billion transaction between ABS and CBN does not exceed or doesn't even reach the transaction value of 50 billion. Is that correct?
That is correct, Your Honor.
In other words, this transaction is exempt from the compulsory notification and approval by the Philippine Constitution Commission up to September 15, 2022. Is that correct?
That's correct, Your Honor.
Now, my question is, when this provision expires on September 15, 2022, will agreements which did not exceed the threshold of 50 billion be required to compulsorily notify and such agreement be approved by the Philippine Competition Commission, or it will not retroact?
Our position is it will not retract. The applicable law at that time will be bayanihan 2, and transactions such as this, which were dated August, will not need to be compulsorily notified, Your Honor.
Thank you. With respect to the motu proprio review by the Philippine Competition Commission, I was reading your enabling statute, and it refers to mergers and acquisitions. Is that correct?
That is correct, Your Honor.
Okay. And there is a definite definition under Section 4 of what is a merger and what is an acquisition. Is that correct?
Yes, that is correct.
And you are bound by the parameters and limitations of this definition. Is that correct?
Yes, Your Honor.
Now, Mr. Chairman, I would reserve further questions when the Philippine Competition Commission would submit a more thorough report. Thank you, Mr. Commissioner.
Thank you very much, the Honorable Edsel Lagman, for your questions to our first persons. Now, we have the Honorable Teves. I don't see him anymore. So now we proceed to the Honorable Vice Chair, the Honorable Barsaga. You are recognized.
Maraming salamat, Chairman. Well, I would be asking some clarificatory questions to our General Counsel of the Securities and Exchange Commission, Attorney Padilla. Is Attorney Padilla still around? Attorney Padilla?
Attorney Padilla of SEC, are you around?
Yes, Your Honor. Yes, Mr. Chair.
Okay. Please speak closer to the microphone. We cannot hear you. Nag-echo. Okay. The Honorable Padilla, the Honorable Padilla, you have the floor.
Attorney, do I get you right when you stated that what was submitted to you, to your office by ABS-CBN was merely the executive summary?
Your Honor, initially po, what was submitted to us in acting on our initial directive was an executive summary.
Okay, so you just received an executive summary. When did you receive that? More or less?
More Monday. We received that Monday this week.
Monday this week.
August 22.
August 22. The executive summary.
Yes, Your Honor.
The executive summary will not be sufficient for you to make an assessment of the entire deal. Is that correct?
Yes, Your Honor.
So what did you do?
Your Honor, we requested for the actual copies of the agreement, Your Honor.
And was that request followed by ABS-CBN?
Initially, Your Honor, they declined because of confidentiality issues. However, Your Honor, after the MSRD or the Market Securities Regulation Department issued a show cause, they complied eventually.
So in other words, you have to issue a cause order in order to compel or convince ABS-CBN to give you a copy of the investment certificate. Will that be a correct appreciation?
That is correct, Your Honor, based on our records, Your Honor.
And insofar as the implication of confidentiality of the transaction, do you agree with the position of ABS-CBN?
With all due respect, Your Honor, we do not agree because as regulators, we are mandated to protect investors, and we can only do that effectively if we are able to review fully the complete documents, Your Honor.
And can you think of any reason why ABS-CBN does not want to submit the investment agreement between ABS-CBN and TV5 on grounds of confidentiality?
Your Honor, what I'm thinking right now is that they would be invoking a provision in the agreement on confidentiality. But it is our position, Your Honor, that the provisions in the contract on confidentiality should not be made to apply to the government.
Okay. So in short, as a lawyer, it is your position, and I agree with you, that if there is a confidentiality provision in the agreement, that is applicable only between the parties and their successors and interests, but not applicable to the government, especially if the agency is a regulatory body like the Securities and Exchange Commission.
That is correct, Your Honor.
Attorney Padilla, so when did you actually receive the entire agreement?
Your Honor, we received it August 22 po.
August 22. Okay. You just give us a chronological sequence of the events. And you have made a very detailed presentation, notwithstanding the fact that you stated that you received it only on August 22, and you have only a period of 2 days to prepare. My request is that, do you have a printed copy of what you have stated a while ago?
Yes, Your Honor. We submitted a position paper already, Your Honor. I can also provide you with a copy of my statement to the Honorable Committee, Your Honor.
And just request the COMSEC to provide us either with a soft copy of hard copy of your position paper. And according to you, you will be making a further scrutiny of the investment agreement.
That is correct, Your Honor. That is correct.
Can you also furnish the committee of the copies of the investment certificate and its annexes?
We will do that. We will do that.
And how long can you do that?
Your Honor, we can submit it tomorrow, Your Honor.
And how many pages are there?
Your Honor, makapal po, Your Honor. The investment agreement, main contract is composed of 24 pages exclusive of the attachments. While
how many pages are there in the attachment?
But we will provide you with the attachment. And the convertible note agreement, at any rate, Your Honor, walang pagination po, or walang pagination dito. We will undertake to provide the honorable committee with a copy tomorrow po, first thing in the morning.
Okay, maraming salamat. Then I will go to Attorney Bernabe. Attorney Bernabe?
Good afternoon, Your Honor.
Magandang hapon, Attorney Bernabe. You stated a while ago that up to the present, you do not have a copy of the investment agreement between TV5 and ABS-CBN. Is that correct, Mr. Chair?
Tama po yun, Your Honor.
Hindi, gawa nung naalala. Yung wala si Kuya, yung kilay ko lalagyan ko. Ano ako sa lamin doon?
May I ask, there are mics on. Can you please mute your mics? The Honorable Barsaga has the floor. Thank you.
Attorney Bernabe, please.
Attorney Bernabe, you have the floor. Attorney Bernabe.
Yes,
Sorry.
I affirm that the statement that we have not received a copy of the investment agreement is correct, Your Honor.
Compañero, I was a little bit impressed with your comments, notwithstanding that you do not have a copy or have not seen the copy of the investment certificate, you were able to discuss in details. And according to you, you just relied on newspaper publications. Will that be correct?
Insofar as the details of the transaction, that is correct, Your Honor.
Well, like you, I've been always researching, and my basis is also the newspaper publications. Unfortunately, I did not have that knowledge which you have manifested to us. So just for the record, what are the newspaper publications which became the basis of your summary and presentation before our committee a while ago?
Just to be clear, Your Honor, the publications that we used for purposes of the details of the transaction are sourced from the press statement of the parties to the transaction themselves. So these are from ABS-CBN and TV5. With regard to other elements of my earlier intervention, Your Honor, which are not specific to the transaction, but relate to the factors that we have to examine if we conduct a review, those are based, Your Honor, on the law, our regulations, our merger review guidelines, and our experience in reviewing cases that have been brought before the Commission over the last 6 years, Your Honor.
Thank you very much. And according to you, in which I agree, that under the Bayanihan Law number 2, the threshold is 50 billion and Bayanihan Law would expire on September 17.
Yes, Your Honor, that is also our understanding.
So insofar as the present threshold is concerned, that would be still 50 billion and not the 1 billion provided for under the law.
That is correct, Your Honor. And if I may also clarify, the 1 billion initially provided under RA 10667 has, over the years, been adjusted to a higher amount given the powers accorded by the law to the Commission to adjust it according to inflation and purchasing power of consumers in the economy. So, in fact, the size of party test, meaning the amount of assets or revenues of either party, must be at least now 6 billion pesos. This was before Bayanihan 2 took effect. And the size of transaction, meaning the assets or revenues of the acquired party, must be at least 2.4 billion pesos prior to the effectivity of Bayanihan 2. But again, to emphasize, until the lapse of the provision in Bayanihan 2, we are compelled to follow the provisions which say that we can only compulsorily require notification of transactions with the value in excess of 50 billion pesos.
Just for the enlightenment of the members, based on your rules, what will be the threshold after September 17?
We are in the process, Your Honor, of making a determination of what the appropriate values are. If we are not going to revise
no, my question is very
value,
simple. Right now, based on your rules, what is the threshold? 6 billion, 3 billion, or still 1 billion?
For size of party, Your Honor, it's 6 billion. For size of transaction, it is 2.4 billion.
Okay. And what is your legal basis? Does the law expressly provide that you have the right to increase the threshold of 1 billion?
Yes, Your Honor. Under Section 17 of the Philippine Competition Act, it clearly provides that the Competition Commission has the authority to adjust these thresholds on the basis of the performance of the economy, Your Honor. The exact term is
The 6 billion and 2.4 billion, were they effective before the passage of the Bayanihan Law?
yes, Your Honor.
And when was the first time that this was applied? The new threshold?
These were applied in March of 2020, Your Honor.
March 2020. And as
Every year, yes, just to clarify, Your Honor, every March of every year, we adjust the transaction thresholds.
Okay. Yung sa 1 billion, ang sumunod na ba kagad 6 billion or 2.4 billion? O meron pa kayong naunang threshold?
May nauna pa, Your Honor. Yes.
Would you just
It
provide us?
progressively increased to these current amounts over the years.
I assume that these new thresholds are in writing.
Yes, Your Honor. We issue resolutions, which are publicly available and posted on our website as well.
And insofar as you are concerned, you made also the statement that this will be merely an investment in the shares of the stock of TD5. Will that be correct?
Your Honor, may I request for you to repeat your statement or question?
Is it correct when you stated that this investment will cover only the investment in shares of stock?
To clarify, Your Honor, what I referred to is that the exercise of the mandate of the Commission will pertain specifically to the investment agreement involving the acquisition of these shares of stock.
And so, in as much as there is an investment in the shares of stock, there will be no violation of the prohibition regarding the provisions of the Constitution, as well as the provisions regarding the franchise that was issued to DP5.
The transactions in and of themselves, unless they result in a monopoly or combination in restraint of trade as provided in the Constitution, are not necessarily prohibited.
No, my question is it a correct statement that this is merely an investment in the shares of stock, and therefore there will be no violation?
There will be no violation of what?
Of the
Your Honor?
Constitution and the franchise. Of the restrictions under the franchise.
As of now, we cannot make a categorical statement that there's any violation, Your Honor.
Hey, well, I think I would be, but you have also made the statement that on account of this transaction, ABS-CBN will acquire 34.99% of the shares of stock of TD5.
That is correct, Your Honor.
And because of the convertible, what do you call that? Convertible
notes to equity, I believe, Your Honor.
After that, it will be exercised for a period of 8 years. And after 8 years, the stock holdings of ABS-CBN in the corporation will be 49.92.
Yes, Your Honor.
Okay, I'll go back to that later. To Attorney Cordoba. Memorandum Order Number 603-06-2022.
Yes, Your Honor.
Initially, can you convince us that you have the power to issue this memorandum order number 003-06-2022?
Yes, Mr. Chairman, the NTC has the power has a quasi-legislative power which it can exercise in regulation of the industries under our jurisdiction, Your Honors.
Well, my colleague, Kong Etchalagman, has read his letter to Speaker Martin Romualdez, and I would request you to answer point by point the allegations made by our dear colleague, Congressman Lagman. Can you do that?
Yes, Your Honors, we will do that.
Another question. Do you have already a copy of the investment agreement between the two corporations?
Yes, Your Honor, we were able to receive a copy of the redacted agreement the other day, Your Honors.
What do you mean by redacted?
What they did was they blocked certain parts of the agreement, Your Honors. I think they were doing that because of confidentiality.
No, but the trouble is that, do you think that the confidentiality stipulation between the parties would also be enforceable or binding upon government agencies like the NTC?
No, Your Honors, because the government has the right to look into the agreements entered into by the parties, Your Honors, to check if it is
What action
within.
will you take, considering that what was given to you was a redacted copy of the investment certificate?
We will issue a subpoena, Your Honor, to ask for the copy which is not redacted, Your Honors.
To expedite matters, can we just request the Securities and Exchange Commission to give copies to NTC as well as to the Philippine Competition Commission? Will there be a violation, Attorney Padilla?
We will share that, Your Honor. We will pursuant to the instruction of the Honorable Congress, we will share our copy to the.
No, actually, it's not an instruction, just a request.
Sorry, Your Honor.
Next question. As presented, after initially the stock holdings of ABS-CBN will be 34.99%. And after 8 years, it will be 49.97%. And this is one question which our resource persons have to consider. Right now, there are two bills which were filed in Congress for the issuance of a franchise before the Securities and Exchange Commission. One filed by our colleague, Johnny Pimentel, and the other one filed by, I think, the Makabayan Bloc. Of course, the franchise application may be granted or might not be granted by Congress. My question is, in the event that the franchise will be approved by Congress, what would happen to this agreement between TV5 and ABS-CBN? You better answer that in writing. Number two, can the parties withdraw on account of the franchise issued in favor of ABS-CBN? Because there will be legal complications, I think. So the regulatory bodies must be ready to answer these questions, because we will be bringing up that issue in our discussion of the franchise application. And finally, we wish to emphasize that we are very grateful to the information and positions of the government agencies. But I want to stress that insofar as franchise is concerned, as mentioned by my friend Congressman Lagman, it is the exclusive and sole domain of the Congress of the Philippines. Your opinion will guide us into what action we shall take, but ultimately it will be Congress who shall decide whether or not the agreement is null and void, whether or not we will approve it, because under the law, we have the right to review any franchise which we have issued, not to mention that we have also the oversight powers over these franchises issued by Congress. That would be all. Thank you very much.
Thank you very much.
The Honorable Barsaga, maraming salamat po. We now proceed to our next interpreter, the Deputy Majority Leader, Benny Abante. You are recognized. The Honorable Abante.
Yes, thank you, Mr. Chair. Can you hear me?
Yes, we can hear you. Please
Okay,
speak
may
up.
I direct my question, Mr. Chair, to the Philippine Competition Commission?
Okay, that's Commissioner Bernabe. So you may now
All right.
proceed.
Okay, you made mention, Attorney Bernabe, that you have the right to notify ABS-CBN on the transaction. Am I right?
No, may I clarify? What I stated earlier is that two things. ABS-CBN does not need to notify us as a matter of obligation, but two, they can voluntarily notify us of their transaction. Now, if they don't voluntarily notify us, we can nonetheless, in the commission, exercise our motu proprio review powers of their transaction.
Okay, therefore, you can officially notify. Am I right?
We can officially review the transaction, Your Honor, to be precise about it.
Okay, but you're also aware, you made mention a moment ago by when Congressman Mogleta was interpolating you on the provision of the Bayanihan 2, am I right?
Yes, Your Honor.
Where it says that the issuance of a directive that all government agencies and LGU shall act on all pending and new applications for permit, license, certificate, clearances, authorization, and resolution without a non-extendable period of 7 working days in order to support business continuity and encourage assumption of all economic activities, provided that the applicant shall be allowed to undertake its compliance to any additional requirement that may be imposed by the government agency or LGU, and such will not delay the approval of the application, provided further that this shall not apply to regulatory processes involving administrative investigations or enforcement activities by government regulators exercising quasi-judicial functions, provided finally that the Philippine Competition Commission shall promote business continuity and capacity building. As such, all mergers and acquisitions with transaction values below 50 billion pesos shall be exempt from compulsory notification under Section 17 of Republic Act number 10667 or the Philippine Competition Act if entered into within a period of 2 years from the effectivity of this act, and further shall be exempt the PC's power to review mergers and acquisitions motu proprio provided in Section 12 of the Republic Act number 10667 for a period of 1 year from the effectivity of this act. It means that if it is under 50 billion pesos, Attorney Bernabe, that you are actually asked by this provision, and that you cannot in any way review mergers and acquisitions. Am I right?
Section 4EEE of Bayanihan 2, which you have read out, Your Honor, states that parties to a transaction whose value is less than 50 billion do not need to compulsorily notify the commission.
Yes.
However, after the lapse of 1 year from the passage of Bayanihan 2, which was September 2021, we can begin to exercise our power to review on a motu proprio basis transactions even if they fall below 50 billion pesos.
Oh, so no, therefore, now you could be able to review. Am I right?
That is correct, Your Honor.
Okay. Well, what I'm thinking is, do you believe that the ABS-CBN and TV5 have actually violated any law on this transaction?
Insofar as the Competition Act, which is the sole purview, which is the sole parameter by which we can judge whether there's a violation, we cannot at this point categorically state that there's any violation. It will have to be after we conduct an economic analysis within the legal framework of the PCA, and that's the only time that we can say if there's any effect on competition which violates the law.
Okay. Well, in your opinion, is it not that the joint venture, as they say, between TV5 and ABS-CBN, ito ay malinaw na shares purchase agreement lamang ito?
It is an investment agreement. I am not sure if we can classify it as a joint venture under the rules of the PCA and the rules that we have promulgated as the Commission. It is from our perspective, an acquisition.
Well, and actually, that would not even be in competition with Channel 7 because right now, GMA7 is wala na competition sa kanila eh. Am I right?
To clarify, Your Honor, that is what I referred to earlier, that perhaps with the investment agreement between ABS and TV5, TV5 will be strengthened to be able to compete more effectively with GMA7. That is something that will be examined by our Mergers and Acquisition Office if we review the transaction.
But at this point in time, there's not actually any competition. Am I right?
There is competition, but there is a dominant incumbent in GMA7, and the balance of 40% is spread out among several competitors. So one might say that you need stronger, viable competitors to be able to say that there's a strong competition in the market.
Ang iniisip ko, Attorney Bernabe, paano maging resulta sa pag-restrict or lessen competition sa TV broadcast industry ang nasabing share purchase agreement? In your opinion?
Your Honor, it would be premature for me to make any categorical statements. There are possible theories of harm, no? So ito po ay mga haka-haka lamang. They're not concrete by any form or means. Some are saying that with the vertical relationship that will be formed between ABS and TV5, baka raw po yung dating napapanood sa ibang media platforms, whether traditional media or social media, ay mababawasan. And therefore, kokonte ang choices ng consumers kung saan nila mapapanood ang mga content, ang mga programa ng ABS-CBN. Pero ito po ay hindi pa natin alam. Kailangan pa po nating makita ang investment agreement at makita ang patutunguhan ng arrangement between ABS and TV5, Your Honor.
Therefore, sa unang hearing na ito ng Committee on Legislative Franchises sa Committee on Trade Industry, wala pa kayong pwedeng ibigay talagang categorical statement on the basis of the privileged speech of Congressman Marcoleta.
Tama po yun, Your Honor.
And not only the PCC, but also the NTC. Am I right, Attorney Cordoba?
Thank you for your question, Your Honors. Actually, at this point in time po, we don't have a copy of the full agreement between investment agreement between ABS-CBN and TV5. But ang tinitingnan po namin ngayon is yung mga past violations of ABS-CBN which we are going through. May kaso po kasi nakafile sa aming
The past violations of which should not even be included right now in this hearing because they are past violations, am I right?
Yes, Your Honors.
Okay, so yun na kiniklear natin. And also the SEC, no? Ibig sabihin, kayo, the PCC, the NTC, the SEC, only made a declaration of the rules that you have, but you have not in reality undertaken any kind of even a kind of opinion over what the transaction of ABS-CBN and TV5 is. Attorney Cordova.
Sir, insofar as the transaction is concerned, we are just looking at the past dun po sa ABS-CBN. But insofar as the present transaction is concerned, we have to get a copy of the investment agreement which is not redacted po, yung pong complete.
That's what I'm saying. It means that you are actually making an advance statement on that when it's already passed. Am I right?
Yes, sir. Dun po sa case po, pending po kasi sa amin yun.
Okay, that is what we would like to make it clear. Now, sa SEC din, ganun, di ba? Hello?
Yes, Your Honor.
Securities Exchange Commission, right?
Yes, Your Honor. We were able to initially evaluate the agreements, Your Honor.
Therefore, we can conclude, Mr. Chair, that these three agencies of government cannot make a categorical statement on the allegations in the previous speech of Congressman Marcoleta, and they cannot even make mention of the past violations, as Attorney Cordova has said, that what we are actually right now hearing are just the rules and regulations that these three agencies is undertaking as far as if they will review or investigate the shares agreement of ABS-CBN and TV5, Mr. Chair. So, yun lang po ang gusto kong sabihin. I just would like to clarify it and thank you for the clarification, Attorney Bernabe, Attorney Cordova. Thank you for the clarification also of the SEC for this. It is made clear to me that whatever will be discussed in here are just actually opinions of the three agencies. Thank you very much, Mr. Chair.
Thank you very much, Deputy Majority Leader Benny Abante. From the majority, we now proceed to the minority. The Deputy Minority Leader, the Representative Franz Castro. You are recognized.
Thank you, Mr. Chair. Maganda po lumipat kayo, no? Naririnig namin ng mabuti ang maganda niyong boses.
Lumipat po ako. Salamat po.
Yes, Mr. Chair, yung iba naman ng mga tanong ko, natanong na rin po. So malinaw po dun sa mga tanungan and interpellation with our previous interpreters that halimbawa po sa PCC, malinaw na yung transaction or investment or agreement is not notifiable transaction due to bayanihan law natin. And number two, the investment between ABS-CBN and TV5 is not a merger but an acquisition of shares. Okay, so ayun po, meron din po na makapangyarihan yung PCC na magkaroon ng motu proprio just in case na hindi mag-volunteer ang ABS na ibigay yung agreement. But nonetheless, Mr. Chair, gusto ko lang tanungin kasi gusto natin talaga mabigyan Mr. Chair ng choices, magandang mga programa, ang ating mga viewers, mga serbisyo, yung ating mga viewers, kaya gusto natin merong masigla na mga competition between yung mga networks and so on. So, ang tanong ko lang po doon sa PCC, Mr. Chair, do you believe that the deals between the ABS-CBN and TV5 investment actually encourage more competition? Mr. Chair, kay ano po, kay Mr. Bernabe.
Okay,
Salamat.
Attorney Bernabe of PCC.
Mr. Chair, and salamat po for that question. Gaya po ng sinasabi ko kanina, mahirap pong sabihin sa punto ngayon na meron or walang benepisyo o kasamaan na idudulot itong transaksyon na ito sa ating kompetisyon sa mga merkado or sa mga industriyang kasama dito. Ang masasabi lang po natin ay ating titingnan ang parehong sides of the effects on competition. Kailangan po nating tingnan kung ano yung benefits at kailangan din nating tingnan kung ano yung posibleng disadvantage sa competition sa merkado.
Yes, thank you, Mr. Chair. Mahalaga yun, ano? Mahalaga na makita natin yung ano doon, ano, yung definite na sagot, 'di ba? Para magkaroon tayo yung ang benefit ng ating public. So kailan po ba tayo magkakaroon ng study tungkol diyan at ano po yung time frame nung sinasabi natin na study po pa kaugnay niyan?
Ang mababanggit ko po dito, Your Honor, is that sa ilalim ng ating mga reglamento, kung magvo-voluntarily notify po itong ABS-CBN at saka TV5, meron po silang meron pong panahon ang Competition Commission na 45 araw para po pag-aralan ito under Phase 1 review na tinatawag natin. Ngayon po, kung makikita natin na may posibilidad na meron ngang hindi magandang epekto ito sa merkado, binibigyan tayo ng ating reglamento ng karagdagang 90 days, no? 90 na araw, na dias, na para tayo siyasatin pa itong transaksyon na ito. Ngayon po, kung hindi po sila mag-voluntarily notify at tayo po ay magmo-motu proprio review, mas matagal po ang panahon na binibigay sa komisyon ng reglamento natin. Tayo po ay merong 75 araw para gawin itong Phase 1 review at 120 araw para kompletuhin ang Phase 2 review. Bakit po mas matagal pag nag-motu proprio? Kasi po yung mga kinakailangang datos sa informasyon ay hindi ibibigay sa atin. Kailangan po nating i-request mula dun sa mga partido at maaari pong minsan hindi nila agad-agad binibigay, kaya po tumatagal ang binibigay na panahon sa komisyon para makumpleto itong review na ito.
Okay. So malinaw po ano yung explanation ng ating PCC kaugnay niya ang sinasabi natin yung sinasabi natin na kung merong violation doon sa basically doon sa competition, no? Kung healthy yung competition ay dudulot ito o hindi. But ako po on my personal view, tingin ko po magiging healthy ang competition kapag meron pong may ganitong mga agreement na mag-i-improve po doon sa services, sa mga program, sa mga content nung kahit na tingin ko po na hindi na natin kailangan na extensive na review, pero tingin ko po talagang magbe-benefit ang public diyan dahil alam naman po natin yung yung mga binigay ng ABS-CBN TV5 for how many years na nasa sila. That's only my my opinion. Tingin ko po yun po yun. Thank you po Mr. Bernabe. Sa NTC na lang po Mr. Chair. Ilang questions. So, hindi po nagbigay sa inyo ng kopya ng agreement ang TV5 and ABS-CBN. Kasi naman po, the deal does not require NTC approval because of, di ba, mayroon tayong 40% threshold for change of ownership. Tama po ba yon?
Actually, thank you very much, Mr. Chair, Madam Franz, for the question po. Actually po, the NTC has subpoena powers, so we were able to ask for for a copy, but ang pinadala naman po kami ng copy, but it's a redacted copy. Kasi po meron daw po mga parts of it which are confidential. But I think si SEC po will be asking for a copy which is not redacted and it will be distributed to everyone else.
Okay, kasi ito lang po ay investment agreement. So meron din po kayong gagawin na investigation later on. So tama po ba yung ang aking impression that it does not require approval from the lower house because hindi po na-meet yung criteria for change in controlling interest?
Actually, ma'am,
Kailangan po ba? Kailangan pa po ba ng approval yan?
Based po dun sa franchise of TV5, ang kailangan po is 50 plus 1%, which is a majority. But I think subject to the wisdom po of Congress, meron naman po kayong plenary powers to check each and every transaction entered into by a franchisee. Based on that supervisory powers and plenary powers of the House of Representatives.
So tingin natin dun sa franchise kasi na ibinigay, hindi naman na-meet yung criteria dun sa change in controlling interest. So yun lang po yung tingin ko doon, no. And lastly, do you believe that TV5 violate its franchise in forging investment or agreement with the ABS-CBN? Meron bang tingin ninyo may mga na-violate?
Actually po, ang nakikita ko lang po na, well, ano lang po ito, this is very preliminary dahil wala nga po we don't have a copy of the whole agreement between, investment agreement between ABC5 and TV5 and the ABS-CBN. But yun po kasing ABS-CBN has past violations po. So yun po ang aming kailangan tignan. Dapat po ay masettle po muna yun as raised by Congressman Marcoleta earlier po.
Ni-raise po yun ni Congressman Marcoleta. Pero sa inyo po, may na-violate bang TV5 sa franchise niya in forging investment with ABS-CBN? Kasi yung sinasabi niyong past violations, alam niyo po, Mr. Cordova, remiss na kayo dun sa inyong dun sa inyong tungkulin. Kasi 2 years have passed at ang sinasabi ninyo lang naman na violation ay yung pay-per-view. Diba? So 2 taon na po yung nakalipas, wala pa naman kayong decision or resolution on that matter. Di po ba? Malinaw din naman doon sa mga pagdinig doon sa franchise ng ABS-CBN before, yung mga BIR requirements, yung mga pagbabayad ng tax ay naano rin naman. Pero ito po, yung sa sinasabi nating TV5 na franchise. So yun lang po yung tanong ko. Yes or no po? Tingin niyo po ba may na-violate?
Sa TV5 po, preliminarily wala po kami nakikita.
Okay. Thank you, Mr. Chair. Salamat po, Sir Cordova, sa inyong mga sagot.
Salamat po.
Maraming salamat, Deputy Minority Leader Representative Castro. We will, before I proceed to the second round, there's a request for a second round. Are there any other members that are present who would like to speak or interpret? Kung wala, we now proceed to the second round. The Honorable Marcoleta is recognized for his second round.
Salamat, Mr. Chair.
You have the floor, sir.
Kay NTC Commissioner Cordova, Mr. Chair.
Proceed.
Commissioner Cordova, kanina po, you were asked by Congressman Lagman of several questions like whether or not you know certain laws that prohibit parties from commencing any contract prior to an undertaking of settling all obligations. Is it not true, Mr. Commissioner, that there are statutes which are embedded in the body of laws that will sustain an answer to his question that until and unless obligations are fulfilled, contracts can be prohibited or can even be stopped. Like contracts of loan, there are obligations of some of the parties that need to be complied with before a contract of loan can materialize, isn't it, Mr. Commissioner?
Yes, meron pong mga conditions that especially
A contract of purchase. There are obligations also before a party can complete the transaction. Even in the contract of marriage, there are obligations that need to be complied with. In other words, certain obligations are mandated in laws scattered in our judicial system that can be cited to support the memorandum that you cited earlier, Mr. Commissioner. Just for your reference.
actually, may I respond, Your Honors? Actually po, ang nakikita ko nga pong magandang halimbawa, Mr. Chair, is that if you enter into a contract for the sale of real property, the transfer of the property will not be registered by the Register of Deeds unless you give a clearance from the city assessor's office or sa local government unit that the real property tax has been paid for that property. That's just one example.
That is correct, Mr. Commissioner. Even a contract of mortgage, there are obligations. A contract of transport, there are obligations. Even in simple life, there are several undertakings and arrangements that obligations are necessary to be complied with. This is supposed to be the case. And this is probably the basis why you made or you executed a memorandum order in order for some errant parties who do not intend to comply with obligations prior to undertaking new obligations. You also responded to the question of the Honorable Franz Castro asking for your opinion whether or not TV5 may have violated this franchise, and in your opinion, which does not bind this committee, Mr. NTC Commissioner, TV5 has not violated. Is that your answer?
Actually, Your Honors, it's a conditional answer because we have not read the full the full investment agreement between the parties kasi po what was furnished our office is just a redacted copy, Your Honors.
Because, Mr. Commissioner, easily I can tell you that in Congress, the approval of a franchise is always assumed on three bases. One is technical competence, financial competence, and administrative competence. These requirements. If financial competence is not there, you will see that the franchise will not be approved. As a matter of fact, I recall, and maybe you're familiar with Presidential Decree 576-A, that particular presidential decree, Mr. Commissioner, provides that a radio station or no radio station or television network may be given a franchise unless it has sufficient capital. Do you recall that?
Yes, Your Honor. That's a condition, Your Honor. Actually po, sa amin po in our office, we cannot give an authority if hindi po na-reach yung 70-30 na debt equity ratio, Your Honor. So a franchisee should have 30% equity bago po namin bigyan ng license.
That is what I am saying. So again, that is already some semblance of, I would say, weakness or violation on the part of TV5 because in their application for a franchise, the technical, financial, and managerial competence were assumed by Congress based on the evidence and documents that they have submitted. Now we are putting into question the financial capability now, Mr. Commissioner, Mr. Chair, because of the sizable and substantial acquisition that represents about 35% of the outstanding capital stock of TV5. Can we now assume that financially TV5 is no longer in a position to support its franchise. That is one issue that you should look into, Mr. Commissioner, considering that you are the regulatory agency that is supposed to be interested in this particular issue. Because based on publicly available documents as cited by the commissioner from the Philippine Competition Commission, I have read a press statement of ABS-CBN, Mr. Commissioner, which says that the proceeds of the subscription in the primary common shares and the convertible note in the total amount of 4 billion pesos will fund the capital expenditures and operating expenses of TV5. This will put TV5 in bad light, and it is an admission that they have now a financial weakness. That is why they are asking for investment. Again, these are, I would say, manifestations of some problems insofar as or doubts insofar as the financial competence of TV5 is concerned. You will note, Mr. Commissioner, that TV5, the parent company of TV5 is MediaQuest. And I think you are in a position to know that MediaQuest is a conglomerate that is owned by PLDT Beneficial Trust Fund. Meaning to say, this trust fund are the ones being utilized. This pension fund is being utilized to acquire media outfits or interest in media outfits. You should look into also into the issue on whether or not pension funds, Mr. Commissioner, can be utilized for other purposes, much less in acquiring assets of existing media outfits. We will have to look into whether or not this funding are coming from Filipino citizens, considering the very strict provisions of law in the acquisition of or in the management and ownership of media outfits. This is something that we will have to look into. Again, I will emphasize that the obligations that you have been citing a while ago are still not complete, because I have cited a lot of violations that have been established during the last hearing, and I think I will be in a position to furnish you some of the details, so that I think it is not too late for you to be able to run after the airing network, considering that these violations have been established. Mr. Chair, I will go to the lawyer of the Securities and Exchange Commission for a short question, if he's still there.
Please proceed, Attorney Padilla of SEC. Attorney Padilla?
Good afternoon, Your Honor. Yes, sir.
Okay. There are some questions raised on the second round by the Honorable Marcoleta.
Attorney Padilla, first of all, I'd like to thank you for your participation and the quite substantial information, even if you were just basing it on some summarized documents that was furnished you, including the redacted copy of an investment agreement. My question is, would you allow or would you accept formally a redacted copy of the investment agreement submitted to you?
Sir, actually, we were just, Your Honor, we were actually earlier discussing with the director of the Market Securities Regulation Department, which is a department tasked to oversee and regulate publicly listed companies. And we are already in the direction of requiring or directing ABS-CBN to furnish us with the non-redacted copy of the agreement, Your Honor.
Yeah, thank you, because as the sentinel of securities in this country, you're supposed to be guarding against any possible misrepresentation in all the documents being submitted to you. And I hope you will not allow yourselves to be recipients of a redacted copy, which means that they are not trying to give you the entire body of information that you're supposed to get. They are hiding from you some basic and critical information from which you will base your responsibility in replying to the mandate as already asked of you by Congress. So, is that a sign that, or will you think that, given the secrecy or the alleged secrecy that they argue, Congress will not be able to get a copy from them, Attorney Padilla, considering that to them that is a very sacred document that not even the Securities and Exchange Commission should not get the entire unabridged copy?
Your Honor, my personal position is that the government, including from Congress and even the SEC, can compel regulated entities to submit documents, especially if the same is required to perform the respective mandates, Your Honor.
That is why, Attorney, these big networks are always emphasizing transparency and accountability. They're talking about pre-press. They're talking about press freedom. But here you are unable to get the kind of copy that you deserve. It is as if that they are mocking the authority of the Securities and Exchange Commission. I hope Congress will be able to give a copy, a complete copy, and if they do that, I assure you we will give you a copy, the same copy that it will furnish the House of Representatives. Thank you very much, Attorney. Mr. Chair, I will go back to the Commissioner of Philippine Competition Commission.
Please proceed. You still have the floor. The Attorney Bernabe.
Yes, Your Honor.
Attorney Bernabe, I beg your indulgence. I know it's late in the afternoon already, and you have so much work. But I am disturbed by the fact that, of course, there are two conflicting laws here that we are invoking. We're invoking Bayanihan 2 insofar as the 50 billion threshold is concerned, which appears to have override Section 17 of the Philippine Competition Act, is it not? But will you not bother to agree with me, Commissioner, that considering that Bayanihan 2 was legislated in the environment of a pandemic, meaning to say it is a recovery act, which of course was legislated in order for our country to recover from the debilitating effect of the pandemic as soon as we can, so that we needed the most that we can get, including putting a 50 billion threshold in order for the commission competition not to look into, meaning to say below that it is exempted. But Section 17, if I go back to that, that is the threshold when we talk about competition per se, where the Philippine Competition Commission is working in the context of promoting the consumer's welfare, while Bayanihan 2 was working in the context of securing our people, because we need to recover as much as we can because of the effect of the pandemic. I'd like to submit to to an opinion that maybe considering that this case is not about recovery, it's about a business deal, it's about an investment. And the primordial concern here is to be able to serve the consumer. It's not about recovery. This investment, this reducted investment agreement, which was supplied to the Securities and Exchange Commission, which is not yet obtained by your office, not even the House of Representatives, is not about recovery, Commissioner. So don't you think that for the greater purpose and within the meaning and mandate of competition, the 1 billion is supposed to be the threshold?
Thank you for that perspective, Your Honor. What I can say is that when deliberations were ongoing with regard to Section 4EEE of Bayanihan 2, the Competition Commission interposed an objection against this increase, even temporarily, for notification thresholds to be set at 50 billion. Our position was premised on the fact that many transactions which harm the economy actually occur within the range of 5 billion to 10 billion, not at that amount of 50 billion. But of course, the wisdom of the Congress which you represent prevailed. And I'm afraid, submit to the principle of dura lex sed lex, that while the law may be hard, it is still the law. And we would be running afoul of the law if we submit our own interpretation of what you legislated and disobey the explicit mandate under Section 4EEE of Bayanihan 2. But having said that, Your Honor, it is not as if the implementation of Section 4EEE, which is not to require notification on a mandatory basis, deprives the Commission of an opportunity to review. I must emphasize that we can review the transaction on a motu proprio basis, or if the parties voluntarily notify their transaction to the Commission.
That is what I'm trying to emphasize, Mr. Commissioner, because even if Bayanihan 2 may have overrode Section 17 of your own charter, it seems to me that the overriding or the more significant aspect of your job now is to be able to safeguard and to look into the welfare of the consumers. Let us not belabor the notification issue, but let us go ahead into the meat and to the very or the center of I would say the very objective why we are having this hearing today, to see to it that competition is not stifled, to see to it that competition, meaning to say not harmful competition will persist, but in the end it's a competition that is healthy, with the object of being able to safeguard the interest of the consuming public. This is what I'm trying to emphasize to you. Thank you very much, Mr. Commissioner. Thank you very much, Mr. Chair.
Thank you, Your Honor.
Thank you very much, the Honorable Marcoleta. Are there any other members that would like to go on a second round?
Mr. Chair.
The Honorable Edsel Lagman is recognized.
Thank you, Mr. Chairman. I am addressing this question, Mr. Chairman, to Commissioner Cordova. You agreed with Congressman Marcoleta that there are certain disabilities with respect to the right to contract. And he mentioned about the contract of loan, the contract of purchase, and even the contract of marriage. Now, let me ask you, Commissioner, can a party who has a tax payable to the national government enter into a contract of loan?
Yes, Your Honor, I think so.
Can one who has obligations to the national government enter into a contract of, say, a motor vehicle?
Yes, Your Honor.
Yes. Can a bride or a groom enter into a marriage where one has obligations to the national government?
Yes, Your Honor.
Yes. As a matter of fact, the contract of a sale of real property is valid, even if the seller owes the government real estate taxes. The effect of this is that the sale cannot be registered without the payment of the real estate arrearages. But the sale is valid. Is that correct?
Yes, Your Honor.
Okay. Now, you also agreed with Congressman Marcoleta that one who seeks investment is a manifestation of financial weakness. Are you sure of your concurrence with the Honorable Marcoleta?
It can be an indication, Your Honor.
But it can be a manifestation or indication that one party desires to grow more and to prosper more. Is that correct?
It can also be a manifestation of that, Your Honor.
Now, let me go to, thank you, Commissioner Cordoba. Let me go, Mr. Chair, to Commissioner Bernabe.
Yes, please proceed, Attorney Bernabe. You're recognized.
Mr. Chairman, may I ask this question to Commissioner Bernabe? When a law amends a prior law, is there a conflict of laws? Or there is none?
None, Your Honor.
None. Because the amendatory law now becomes more ascendant than the amended law, either permanently or for a time being. Is that correct?
That is correct, Your Honor.
Now, with respect to the present provision in the Bayanihan Hill as one, with respect to the increase in the transaction threshold to be covered by mandatory notification and approval by the Philippine Competition Commission. May we know whether there is an exception to the exception?
No, there's none that we are aware of, Your Honor.
There is none. There is none. And irrespective of whether the circumstantial setting for the enactment of the Bayanihan 2 was the pandemic, the fact is this law is valid and legal and has to be enforced even by the Philippine Competition Commission. Is that correct?
That is correct, Your Honor.
Thank you very much, Mr. Commissioner. Thank you, Mr. Chairman.
Mr. Chair.
Very good.
Thank you very much, Honorable Lagman.
Mr. Chair.
Yes, Honorable Marcoleta.
May I have a rejoinder, Mr. Chair? I'll address the NTC Commissioner.
Yes. Honorable Marcoleta, you have the floor.
Mr. Commissioner, when you when we were asked questions from the Honorable Lagman, you were answering in your capacity as the commissioner of the NTC. Is that correct?
Actually, Your Honor, I was answering as a lawyer, Your Honor, because the questions are general principles of law.
Yes, but you are also answering in the context as the commissioner of the National Telecommunications Commission.
Yes, yes, Your Honor.
Because as a regulator, it is also your duty to look into the best interest of the parties, which are guarded, which are not guarded, because it's not like two parties without the participation of a regulator, like a seller and the buyer, or the contracting parties to a marriage. You are a regulator. You're representing the National Telecommunications Commission. That's why you're after the obligations of each parties. For example, in the extrajudicial settlement, Mr. Commissioner, of course, before the extrajudicial settlement is approved, the existing debts of the decedent or the of the estate is first to be settled. This is not Mr. NTC Commissioner.
Yes, Your Honor. Actually, Your Honor, can I add some more details to the answer?
Okay.
Actually, Your Honor, the reason why we issued this memorandum order is because the franchisees, aside from being given a franchise by Congress, is also being given the privilege by the national government to use the frequencies which is owned by the national government. So if they are given that privilege to use such frequencies for commercial purposes, then it is our position that the national government, in this case represented by the NTC, can give conditions to contracts entered into by franchisees and who are given frequencies by the national government, Your Honors.
Thank you. Can I go now back to the NTC, the Commissioner of the PCC, Mr. Chair?
Proceed, please. Please proceed.
Commissioner Bernabe, are you still there?
Yes, Your Honor.
He's still here.
When I made the submission between Bayanihan 2, Section 4 EEE, in juxtaposition with Section 17 of PCC, did you get the idea that I was trying to ask you not to belabor on the exacting provisions of Bayanihan 2, considering that it was enacted in the context of the pandemic, but maybe to concentrate on the mandate and the mandate of the PCC, which is supposed to be to safeguard and look after the interest of the consumers, which means I was only asking your opinion that between the two laws, even if there is no conflict there, but the overriding idea is not to belabor between the two laws, but concentrate on the very aspect of competition that will be more harshful if not taken as in this particular case. That is so the idea that I was trying to convey, Mr. Commissioner, if you get the idea, but not really to conflict the two cases or the two laws for you to answer. Did you get that idea, Mr. Commissioner?
When I took your entire statement, Your Honor, at the conclusion, I was clear in the understanding that what you wanted us to do was to exercise our power to review the transaction. And such power to review is distinct and separate from the power to require notification. The power to require notification is what is amended by Section 4EEE of Bayanihan 2. But the power to review is not amended. And that subsists regardless of Bayanihan 2. And that is my takeaway from understanding in whole your earlier discourse with this representation, Your Honor.
Thank you very much. Mr. Commissioner, also, I assume that Congressman, when Congressman Lagman read his letter to the Speaker, I assume that you have understood that completely. You have heard some of the points, not like in one of the points that he raised in his letter. I think he was telling that the agreement or the investment between ABS-CBN and TV5 is not a merger, neither a consolidation, and that is why it is not subject to the review of the Competition Commission. I think that was the gist of his letter, and aside from that, he said that the franchise of TV5 was not violated because that is not a merger. It's a simple partnership and an investment. But did I hear you right when you said that the substantial acquisition of the outstanding stocks of ABS-CBN to you had the character of an acquisition? Did I hear you right say that?
If I may clarify, Your Honor, Mr. Chair, I think the Honorable Congressman Edsel Lagman made 2 points in his letter to the Honorable Speaker. The first is that the deal is not a merger. And I think on that point, we agree with Congressman Lagman. The second point that Congressman Lagman made in his letter is that it is not an acquisition as defined in Section 4 of the PCA. And I understand that his premise for this is because an acquisition as defined must be for the purpose of obtaining control. Now, the determination of control is provided for in the PCA as well. It is in the form of an illustrative list of factors that the Commission has to consider. Now, it may be that while there is a presumption that that control is being acquired if you acquire more than 50% of the voting shares of an entity, there are other factors that you can consider as a Commission when determining the existence of control, and therefore a categorization that a transaction is an acquisition. It is an examination of these other factors which might manifest badges of control that I was referring to when I said that, at least in my own opinion, this transaction would qualify as an acquisition. Now, I do not want to preempt the opinion of my other colleagues in the Commission. We are a collegial body, Your Honor, and they may have their own appreciation of whether or not the transaction manifests badges of acquisition of control, which would qualify it as an acquisition. But to my mind, at least personally, there seems to be indications that this qualifies as an acquisition. Now, we do not have a copy of the investment agreement. What we have are the press release from the parties. What we have are the interventions, the notes we have made out of the interventions propounded earlier. And from what has been stated, it would seem that this qualifies, to my mind, as an acquisition. But just to clarify, whether or not it is an acquisition which necessitates notification, that is something which I demur from categorically stating, because I don't think it is an acquisition which is required to be mandatorily notified, Your Honor.
Thank you for that answer, Mr. Commissioner. And in characterizing that it is, in your opinion, an acquisition. It is based on Section 25 of the Charter of PCC. Is that correct?
The application thereof, yes, Your Honor.
Yes. And so you're correct there. I think your opinion jives with my own, because I believe that even if we do not technically classify it as an acquisition, but the badges or signages of control might be there, like the circumstances or situations listed under Section 25 of the Philippine competition law, is something that you should be looking into in the future, Mr. Commissioner. And do you believe that in reviewing Section 10 of the franchise of TV5, because I believe the term merger as utilized in Section 5 of that franchise was used in its generic sense. Because if you will review Section 10, and I think you did already, the substantial acquisition of outstanding stocks of TV5 had the effect of giving to ABS-CBN the exercise of the rights and privileges that are prohibited under that particular section of the franchise of TV5. Considering that the enjoyment of the rights and privileges, more particularly the production of content, which is something that can control the entire operation of TV5, that is supposed to be with prior approval of Congress. That was the point that I was trying to raise in the privilege speech, Mr. Commissioner. That is why even if my good friend and colleague, Congressman Lagman, will technically say that there is no merger, there is no consolidation, but in the context of control, as we have been discussing and as you have elicited, this is really something that the Competition Commission should look into and guard against, because you exist for the interest of the consumers, Mr. Commissioner. That is all, Mr. Chair, and thank you very much, Mr. Commissioner.
Thank you very much, Honorable Marcoleta. Due to time constraints, we now would like to suspend our hearing, and if needed in the future, we will call another hearing. I'm sure there are other hearings kasi may mga ibang bills pa na pertaining to this issue. Anyway, I would like to thank the members that are present, and of course, our resource persons from the SEC, PCC, and NTC. So, to end, do I hear a motion to adjourn from a member of the Committee on Franchise? Please proceed. Yes. A motion? Is there a motion? Please unmute your mic.
Motion to adjourn, Mr. Chairman.
There's a motion. The chair hearing no objection. For the Committee on Franchise, this hearing is adjourned.
On the part of the Committee on Trade and Industry, this joint committee hearing is hereby adjourned.
My co-chair, Marvin.
Thank you, Mr.
Thank
Chair.
you, Mr. Chairman.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
There being no other speakers, thank you very much. Maraming salamat at magkita-kita po tayo ulit. Thank you very much for your time, and it's truly appreciated. Maraming salamat. Magandang gabi sa atin lahat.